Good morning. I'm Chief Judge Blackburn Rigsby, and I'm joined this morning by Associate Judge Easterly and Associate Judge Schenker. We have three cases. Counsel, are you ready to proceed on our first case? QUINN RACUSIN GAZZOLA Chartered versus PAVICH Law Group et al. Are we ready?
Thank you, Your Honor. I am prepared to begin.
All right. And counsel, it's fine if you argue from there, but we can also adjust the podium if you prefer to argue from the podium.
I think actually your courtroom staff has been very accommodating in getting me set up.
Okay.
And I'm comfortable here as long as you are.
You're fine. Thank you.
Great, thank
All
you.
right. Would you like to reserve any time for rebuttal?
I would, maybe 3 minutes, please.
Yes. Right. Please proceed.
May it please the court. My name is Robert Kelly with the firm of Jackson and Campbell, and I represent the appellant in this appeal, the law firm of QUINN, RACUSIN, and GAZZOLA Chartered, which I will refer to herein as appellant or QRG. And let me begin by thanking the court for inviting counsel to address the impact of the recent decision of the U.S. Supreme Court denying appellee, in this case, Wyoke's petition for a writ of certiorari, thereby allowing to stand the decision of the U.S. Court of Appeals for the D.C. Circuit, vacating the judgment of the district court in Wyoke versus Republic of Iraq for want of jurisdiction. We believe the impact of that decision of the Supreme Court, allowing the Court of Appeals decision to stand, is actually dispositive of this appeal and justifies this court in reversing the Superior Court and vacating the arbitrator's final award.
So are you saying that the Supreme Court's denial of cert allowing the judgment in the district court to stand moots out these proceedings?
It can be viewed as mooting it out or as making performance by Wyoke, the promisor, impossible as a matter of law. And either of those approaches results in the same thing, that the attorney, the agreement concerning attorney's fees, the ACAF has been referred to throughout here, is void or no longer.
What do you make about your opposing counsel's argument that the monetization of a portion of the judgment keeps this dispute alive, or at least prevents us from determining that it's moot?
Right, Your Honor. I think the answer to that is fairly simple, and that is that the ACAF itself says that the money has to be, quote, from or on behalf of Iraq. And the monetization that they're alluding to.
Can we look at the language? I mean, I just want to make sure that I understand it.
Could I just ask you to finish that last little piece, the monetization that they're referring to? Because I want to know the answer to Judge Easterly's question also, but I didn't hear the end of your response.
Sure, Your Honor. The ACAF specifies that the money has to be from or on behalf of Iraq. The monetization that counsel is describing is not from or on behalf of Iraq. It's a totally separate source. It is, and therefore there is no recovery to be had once the judgment, which was in excess of $120 million, was essentially vacated by the Court of Appeals because of the lack of jurisdiction due to the Foreign Sovereign Immunities Act, which precluded the lawsuit against Iraq in the first place.
Counsel, I have questions about the monetization, but I just want to focus on the language, because the from or behalf on Iraq language is in the paragraph that you're referring to, but there's more language. So I just want to make sure I'm reading it in context. So it says, Wyoke will pay to the law firms a total contingency fee of 46% of all gross amounts actually recovered and value received by Wyoke, including from collection or settlement or transfer of any interest in the claims or recovery thereon from any source from or on behalf of Iraq arising out of or relating to Wyoke's claims against Iraq or the litigation. It's just a lot of words. I'm not sure that, I mean, what do you make about what do you make of the language that says including from collection or settlement or transfer of any interest in the claims?
Well, Your Honor, I think that we stress the concluding clause, that modifies or constrains the entire.
But you could have an interest, I mean, this is maybe getting into the monetization question. I could have an interest in claims from or on behalf of my Iraq lawsuit, right? I could think, I'm gonna win that suit, I'm gonna win $120 million, but I can't wait. So I'm gonna sell my interest, maybe this is what the monetization is, that I'm blurry about, but I'm gonna get an advance or a loan, or I'm gonna, transfer my future $120 million interest. And I'm gonna get $60 million now from somebody who's willing to wait. That would still be, I would think, arising out of or relating to my claims against Iraq, right?
Even if it is, though, Your Honor, our position is that it still has to be from or on behalf of Iraq, and that.
But doesn't that
qualifies.
read out the other language from collection or settlement or transfer of any interest in the claims or recovery thereon from any source? But what does the from any source mean?
Well, we're speculating at this point, but I suppose it could be if there were a settlement with Iraq, for example. There could be.
Why would it be from any, I mean, why do you need from any source if it's from Iraq? You already have Iraq in there. I mean, what? And are you saying that you think this term is ambiguous?
I'm not saying that it's ambiguous. In fact, I'm saying.
This provision, this part of the, I mean, you're saying we're speculating as far as what it means. So if we don't know what it means, then what do we do?
Well, I think our position is we rely on that terminal clause, that it's got to be from or on behalf of Iraq, which this clearly is not, in our view. And
okay, and
that's
so
our
we
position.
ignore the from any source.
I don't think we're ignoring it. I think we're from any source by or on behalf of Iraq, and or from or on behalf of Iraq.
Can I just ask a factual question? What do you think your colleagues on the other side are talking about when they're talking about monetization? I mean, we have no assertions were made about monetization. I don't believe we were given any details about what that monetization is.
I think we're pretty much in the same position as you are, Your Honor. We really don't have much information.
And are you in a position to say whether or not Y Oak monetized the award?
I'm not in a position to say that. That's perhaps better directed to counsel for the appellees.
Well, if it had been monetized by a third party, the award, why would QRG and care about the other law firms getting a percentage? They're getting less than what the judgment originally was. Again, we're presuming, we don't know the terms or conditions of any monetization.
Good.
It's a lesser amount than the total judgment that was awarded and then vacated. If there's money that was recovered, why shouldn't the other law firms get a portion of that? And why should QRG care what source it's from?
Good question, Your Honor. The ultimate reason is we don't care in many respects, but except for the fact that how it impacts this case and this appeal. Because our view is that since there is no contingency fee to award in the absence of a judgment paid for from or on behalf of Iraq, that the case, that the ACAF essentially is moot or void for impossibility of performance.
So counsel, the ACAF may be void or impossible to perform, as you say, but in terms of the mootness question, which is sort of separate, related, what about the tort claims and the damages that were awarded under those?
Well, our position there, and that's a good question that I was prepared to address, and that is, the answer is that the sole purpose of the ACAF, as we see it, was to adjust the contingency fee amount the percentage amount to 46% to accommodate all the work that the four various law firms involved in the prosecution of the YO case, the litigation team, if you will.
Well, how do you
was
say it's
conducted.
the sole purpose? Because there are multiple paragraphs. I mean, that's the first paragraph after the therefore. But the second paragraph is about cooperatively supervising the appellate advocacy and judgment collections. And the third paragraph is about how are we going to resolve disputes arising out of this agreement? And so it seems like those other two paragraphs are still operative.
But also we're getting, I mean, now we're getting a little bit into the merits of arbitrability. And my question was about mootness in terms of the vacator of the judgment.
Right, and what I was,
Yeah.
what I was getting at was that, uh, our position is that the 46% adjustment was basically the central purpose of the ACAF itself. And if that is no longer, if that is now moot, then the ACAF itself is moot. So it's not as though you can carve out that section and call that moot and leave the rest of it.
Well, but you, I mean, at the end, you still have an award by an arbitrator that's been confirmed by the Superior Court. And the question is whether this case is moot before us now, and you've got a separate award issued by the arbitrator that was confirmed by the Superior Court, separate and apart from the 46%. So I'm trying to figure out where that leaves us on mootness.
Well, again, I think that it all falls back onto our position that the central purpose of the ACAF was the adjustment of the 46% contingency fee. If that adjustment is moot because there is no contingency fee, then the ACAF as a whole is moot. We also have a parallel position that because YO could not perform on its promise to pay the contingency fee in the absence of a contingent of an award, that the contract became impossible of performance. And I think all the elements of impossibility of performance are met here. So that in itself would result in voiding the contract. The elements are unexpected occurrence of an intervening act, that the risk was not allocated by agreement or custom, and the occurrence made performance impractical. And what I would suggest is that given the district court, Judge Lamberth's very persuasive analysis confirming his own jurisdiction, which of course was later overturned, but at the time it looked very persuasive, and the award of a favorable verdict against Iraq, the contrary decision of the Court of Appeals would satisfy the requirement of being an unexpected intervening act. So the
It sounds like you are interpreting the agreement and you're saying, well, because the judgment's been vacated, it's impossible to perform this agreement. Is that a claim or dispute between the aforementioned parties arising out of or relating to this agreement? I mean, should this be subject? Do you need to go back to the arbitrator about this? I mean, it sounds funny, but I'm not joking.
I understand. I'm not. I'm just preparing my answer. It's actually. I mean, I think it's not something that arises under the ACAF, because it is what we're saying is that the ACAF.
You're interpreting the ACAF. I mean, you're saying because the judgment has disappeared, we can't perform under this agreement. That seems like an interpretation of this agreement, and that seems like something that you agreed to arbitrate.
Well, it means that YO can't perform, which I think voids the ACAF from the beginning. So it wouldn't leave anything.
Voids it from the beginning or moots it at the end because the judgment was vacated?
Yeah, Your Honor, it's a narrow point, but I think the ultimate result is the same, whatever verbiage you use. There are two different ways to get there. One is mootness and one is impossibility of performance.
Can I ask a question? Are QRG and YO's interest completely aligned in this matter at this point?
I don't believe so. It's, I mean, our principal adversaries, of course, are the other law firms that benefited from the arbitrator's decision. The White Oak did not recover anything under the arbitrator's decision, and in that sense is not adverse to QRG.
Was there any other questions? I know you reserved some time for rebuttal, but.
Yeah, well, Your Honor, I haven't even touched on the merits issues. I mean, assuming that I don't believe that you should reach them because of our principal argument on mootness or impossibility of performance. But, we have articulated a number of arguments on the merits. I guess being out of time, I could
Well,
rely on-
you could take a few more minutes. I know we've had a number of questions for you, but I thought you said that the trial court's confirmation of the arbitration award should be vacated. Did I understand you to say that earlier?
Yeah. What ultimately what we're asking this court to do is to reverse the trial court's decision denying our motion to vacate the award and reverse the Superior Court's action granting respondents or appellees here cross motion for confirmation of the final award, and also to vacate the final award itself.
But
Do we do that without reaching the merits, or we reach the merits? Do we do that under your theory that it's moot because the district court judgment was vacated, or do we do that on the theory that we need to reach the merits on that?
Well, it depends on how your honors rule on our principal argument. We view that as controlling and dispositive. But if you don't agree, then we would move on to the arguments that we have on the merits, which have been laid out in the briefs, which we could rely on here. But I could go through them real quickly if you prefer.
I mean, on the merits, you seem to think that the arbitrator didn't have the ability to arbitrate this dispute, the dispute about the tort claims. But the arbitration agree, I mean, the ACAF says that you agree to arbitration pursuant to JAMS rules, and the JAMS rules say that the arbitrator has the authority to decide jurisdiction. The Supreme Court didn't decide that case in Henry Schein, but the circuit cases before and after seem to be pretty uniform that under the federal arbitration rules, when you have an agreement like that, then it, incorporates by reference arbitration rules that allow the arbitrator to decide arbitrability, that you've essentially contracted to allow the arbitrator to decide arbitrability. I'm not quite sure I understand what your argument in response is to that.
Yeah, that's obviously an important issue, Your Honor. And we begin with the premise that arbitration is a kind of the outcome of a contract.
Absolutely.
And
that's what Henry Schein says. I mean, that's very clear. But the point is, it's a contract, and you can contract to allow the arbitrator to decide arbitrability. So why haven't you done that on this record?
Because we believe that the strict JAMS Rule 8B and the streamlined rules applies, but only within the confines of what the mandate was to the arbitrator in the first place. That mandate did not include allocating the contingency fee, and it did not include any of the tort claims. I think it's quite
Do you
clear.
have any cases that support that understanding? I mean, it seems like the federal cases interpreting the analogous Federal Arbitration Act have not limited this sort of delegation of authority to an arbitrator in the way that you're suggesting we should do it here.
I think it flows from general principles, Your Honor.
I understand, but there are more specific cases about arbitrability, and so you don't have any more specific cases in the
Nothing more specific at this time.
Okay.
All right, counsel, we'll reserve your 3 minutes for rebuttal unless there's any final points you want to make now.
Thank you, Your Honor.
Thank you. Counsel.
Thank you, Your Honor. My name is Eric Rowe. Represent Appellant Whiteford Taylor in this appeal, but I'm going to speak today on behalf of all of the appellees, including Wyatt. And the court should affirm the judgment below. The arbitration order is properly confirmed. The motion to vacate was properly denied. And for reasons largely suggested by Judge Easterly.
So can I ask you to pause just 1 second? Looks like we're having technical issue here.
Okay, sorry.
Thank you.
And for reasons that were articulated just by Judge Easterly, when you have a contract that delegates the decision on arbitrability to the arbitrator, the decision of the arbitrator on that question is the same as any other question that's presented to
So
the
can
arbitrator.
I stop you just for a second before we get to the arbitrability issue? Why isn't this moot? I confess to being a little surprised at the supplemental briefing indicating that it's not moot because of a monetization of at least a portion of the judgment award. And
Right.
Can you just fill us in on what was meant by that and explain how that would not moot out this issue, this case?
Certainly, Your Honor. And there are certain confidentiality restrictions that we're under with regard to some of the specifics of the monetization. But generally, I can say that there was a transfer of an interest of this judgment during the course of the proceedings.
A third party, not one of the
to
appellees.
a third party that will result in a monetary recovery for Wyatt.
Transfer by whom? By Wyoke or by
By
the
Wyatt,
firms?
yes.
And,
And
and we
and-
don't have, I mean, you're making that representation to us,
Mhm.
but we
And-
don't have any record information. I mean, you're saying there are confidentiality issues, but it seems like your whole argument rests on us
Well,
proving that there has been this monetization that we have no
And-
information about before us.
Yes, Your Honor.
Nothing in the
And-
record.
But what I can say is that this is reflected many times in the joint appendix. It's referred to many times over. And one of the things that we talked about in our supplemental
Do you
brief.
reference those references in your pleadings,
We
in your
did.
supplemental pleadings?
We did. And and because the monetization occurred during the course of the arbitration proceeding, you know, one of the tort claims that
Is
was
it a
being,
monetization? I'm sorry, we keep jumping in here. Was it a monetization of the full amount of the
was not the
judgment?
full amount, Your
Okay.
Honor. It was less than the full amount.
So say, and we're going to come back to some more questions on
Okay.
this, but say there is a monetization, as you say there is. Are you suggesting that that monetization comports with the language in the ACAF agreement such that it's still possible to apportion out the recovery from the monetization? And if that's the case, that's not really a part of this lawsuit, isn't it? Is it? Even if
Well-
we moot out this case because there's no federal district court judgment, that doesn't necessarily preclude the appellees from recovering a portion of the monetized judgment, does it?
That's correct, Your Honor. It does not preclude them from recovering that. And that's what I was saying is that during the course of the arbitration case, the monetization occurred. And one of the claims that was being asserted, one of the tort claims that was being asserted against QRG was a tort claim for fraudulent inducement of contract, that the firm involved was hired under false pretenses by QRG. They were not told the truth. And that meant that if this case resulted in a zero recovery, this firm would have invested a fairly large amount of money and attorney time into the case for which they would have no recovery based on the false representations that were made at the inception. Because of the monetization, and this is in the record, it's in our briefs, and the citations to the record are there. Because of the monetization, we were required to drop that claim because there was going to be a recovery and there was going to be a contingent fee paid. And so the claim for fraudulent inducement of contract by my firm had to go away.
I'm sorry to interrupt, but I thought I saw an admission by, is it your firm? I'm having trouble keeping you all straight. I apologize. By WTP, something about a monetization. But I don't know that I saw a reference of monetization by Wyoke.
Well, but Wyoke is the party who's entitled to the judgment. Wyoke is the party who is selling the interest in the judgment, okay? Who is conveying the interest in the judgment in exchange for a sum of money. And, you know, having done that, having entered into this financing arrangement, Wyoke is going to cover money in this case, and the attorneys that are involved are going to be entitled to a contingent fee on the recovery.
But so, I mean, is it true that QRG was not aware of this monetization?
Well, they were certainly aware of it. They were absolutely aware of it. And we've referred to some of Mr. Quinn's testimony with regard to that in our response papers.
Guess I'm just, I don't mean to be a stickler on this, but I see reference to record materials talking about WTP's successful insurance and monetization. And it seems like, I mean, you know,
That's because
maybe WTP could monetize its prospective interest, but I don't see, I mean, you're representing to us that Wyoke monetized, and it seems like for this to go anywhere, it has to have been Wyoke that monetized.
and it was, Your Honor. I mean,
But
and
there's not, I don't see any, and you know, maybe the parties can direct me, you know, your co-counsel can direct me to where I'm missing it in the supplemental pleading. I don't see anything that's talking about record materials that talk about Wyoke's monetization.
and the reference that you're referring to is because one of the Wyoke attorneys negotiated the agreement, Your Honor.
But-
And
Is that in the record? I mean, I appreciate the
Yeah,
representations. and
I can tell you, Your Honor, that nobody,
You know, challenge the accuracy of them. You're asking us to say that this agreement is still in full force based on information that we have no record support for, as far as I can tell. We have stray references to monetization by WTP.
right,
as
and
far
there
as I
are
can
references,
tell.
and there are also references by the other firms, and I think we've also
By the
cited
other
to,
groups, but by Wyoke's, it would seem to be is the critical point.
right, well, it's Wyoke's judgment is the reason for this.
Well, I
Okay,
get that, but WTP, I mean, theoretically, I'm not a betting person, but I could say, I think, you know,
Mhm.
I think Judge Schenker is gonna win the lottery and he owes me, you know, X amount of dollars. So I'm gonna get somebody to advance me the money that I think Judge Schenker is gonna pay me sometime in the future, right? That theoretically, that could happen. And so who knows what this monetization is that's being represented to us, but there's no, as far as I can tell, evidence of monetization directly by Wyoke, unless you want to point me somewhere else. to
Well,
show
I
me
mean,
that.
I think what you're referring to in some ways is a difference between a law firm monetizing its contingent fee and the client monetizing its recovery. And one of the law firms in this case did have an arrangement with a litigation funder to monetize part of its contingent fee.
So
But that's not what we're talking about here.
if there's been a monetization of the judgment,
Yes.
does that comport with the language in the ASCAF, that says the 46% of the total contingency fee
Yes.
recovered? And the language specifically referring to recovery from Iraq, how? Or
Well,
is that
because-
an outside third-party recovery that's not grounded in this language?
Right, because first of all, I would say this dispute over the language and the meaning of it is a question over the interpretation of the agreement, which is ultimately a decision for an arbitrator to make, not the court. But that being said, you know, the language is such that it applies to money recovered from any source. And any source includes any transfer of interest. And the transfer of interest is monetizing the judgment. It is selling a piece of the judgment or conveying a piece of the judgment in exchange for money.
So you're looking at this from the perspective that it doesn't really matter if the district court judgment, which has a different apportionment of the fees to be paid, doesn't it?
No, it's all the same, Your Honor, because the total 46% was to all recoveries from any.
Right, but the district's court's judgment, I thought, included a portion that would go to QRG, which is left out of the arbitrator's award.
Well, no, because There's
Does
two
it-
different parts to this. One, QRG got a 0 award in the arbitration. Because QRG asked for a 0 award in the arbitration. So they were allocated nothing in the arbitration award because they asked to be allocated nothing in the arbitration award. Now, so the rest of the monies that were allocated in accordance with the award. And if you look at the actual judgment that was entered by Judge Kravitz,
Well, no, I was comparing the, okay, go ahead.
and he says, in the event of, and this is the final paragraph in the judgment below, the amended judgment below, this is joint appendix at 750. Ordered that in the event of receipt by WIOC of any monies related to the Iraq litigation, 46% of such gross recoveries shall be distributed as follows. Now, that's any monies related to the Iraq litigation, and monetization would certainly fall within that category. The judgment is not monies recovered pursuant to enforcement or execution on a judgment against the Republic of Iraq.
And so does that have to occur in the context of, you're suggesting then that the arbitrator's award has been confirmed and that this court should affirm it, and that the party should be allowed to apportion the monetized judgment in whatever amount that is, we don't know, because that's not part of this record,
So,
in the same way that the arbitrator's award would have purported to apportion
because
the judgment.
it's our position that the arbitrator's award applies to the monetization recovery.
But okay.
Okay. And
But the arbitrator didn't know about the
He did.
monetized recovery.
he absolutely did. And he discusses it in his final award. I think we've cited to a part of his discussion in our response papers. I mean, the arbitrator knew all about it. And one of the reasons, like I said, one of the reasons that the fraudulent inducement claim was dropped by Whiteford was because of the monetization, and that's reflected in the final award. And I think we cited to those pages in our briefing.
If you, maybe your co-counsel could point us to that, but you're saying the arbitrator knew of a particular amount of a monetized award,
I
or,
don't know if he knew the amount or not, Your Honor.
and that's referenced in the arbitration agreement, or was that an understanding of the parties to the arbitration, but not necessarily specifically referenced?
Well, the arbitration agreement was entered into in December of 2019. The monetization, I think, occurred in 2022.
So the monetization occurred after the ACAF was entered into, during the arbitration.
Yes.
So isn't there an argument that QRG, that the agreement to the ACAF was based on information that has since been changed based on the decision to monetize after the parties entered into an agreement and agreed to arbitrate?
Right. And this occurred during the course of the arbitration case. So if QRG wanted to make that argument and say that the contingent fee part of the ACAF does not apply to monetization proceeds, they certainly could have made that argument in the
Well, that's a
arbitration.
different argument, right? Not that the contingent fee doesn't apply to the monetization amount, but that the ACAF is now, and maybe they didn't make this argument, but that the ACAF is essentially based on outdated information, and that perhaps the ACAF wouldn't have been entered into, at least by QRG. This is an argument they could have made. Maybe they didn't make it. But perhaps they wouldn't have entered into the ACAF on the knowledge that WIOC's ultimate take might be monetized.
Well, I'm not sure how that follows, Your Honor, because when the ACAF was entered, we had a judgment from the district court. The judgment was going to be appealed. Whether it was affirmed on appeal or not, no one knew. It could be affirmed, it might not be affirmed. And one of the things that we argued in the arbitration was that lawyers who have recovered a judgment of this magnitude almost have a duty, or maybe do have a duty to their client, to go out and try and monetize it to protect against the risk of reverse on appeal.
So does WIOC,
Such that there will be a recovery. And that was one of the things that was argued in the arbitration case that Mr. Quinn of QRG hadn't done. And in fact, then it was done. It was done during the course of the arbitration case.
Does White Oak still have a legal claim to those funds?
Sure.
So White Oak received the monetized funds for the judgment, not,
Correct, Your Honor.
not the law firms, or at least not yet.
The money is payable to Y Oak,
Mhm.
and then Y Oak in turn owes the law firms their share of the fees that attach to those funds
Based on what?
based on their contingent fee agreements and the arbitration award in this case.
The contingent fee agreements, the ACAS, I keep forgetting how to do those.
Because and this gets back to this, recovery of monies from any source. And, because it was not merely just, if we recover from this particular defendant, the contingent fee applies only to that. Is if we recover any monies from any source related to this litigation, that's what the contingent fee attaches to. And that's what happened here. And then after the judgment was entered and the monetization agreements were reached, then everybody agreed during
To
the
which
course of
judgment?
this,
The district
that-
court judgment or the arbitration award?
during the course of the arbitration, everybody agreed that when the judgment was monetized, that the contingent fee would apply to the monetization proceeds. There was never a dispute about that.
Everybody agreed. Is that a written agreement or is that a discussion in the course of arbitration? And is that reflected in the arbitration order?
Well, let's just say that no party to this case, not my firm, not the other firms, not Y Oak, not even QRG until 2 weeks ago, made any argument that the contingent fee was not applicable to the monetization proceeds. They came up with this argument in response to the question that the court asked. It's brand new. Nobody argued this before. And if they had an issue like this that they wanted to raise about whether or not this particular agreement, which has an arbitration clause in it, applied to the monetization proceeds or not, they could have raised it during the course of the arbitration. And one of the things that we talked about in our response to the court's question was the fact that they did not raise that issue. Instead, they took advantage of the fact that the contingent fee applied to the monetization in order to reduce their own liability in the tort claims. So this is brand new from them. Okay.
Any further questions? All right, thank you, counsel.
Okay.
All right,
Did you want me to address the merits at all on the arbitrability issue?
if you want to take a minute or two to do that.
Okay, well, and all I would say about that is that with regard, that there is a fundamental rule in arbitration law that when the parties have entrusted to an arbitrator a decision on a particular question, the merits of that question are for the arbitrator and not the court. The question for the court is whether or not the arbitrator had the power to decide a particular issue and whether he did in fact decide a particular issue. In this case, the contract that's involved, the ACAF, provided for anything having to do with it that's going to be referred to arbitration, that the arbitrator could decide those. And then the JAMS rules, which everybody also agreed to, provided that the arbitrator would decide questions of interpretation or scope of the agreement, whether or not the agreement even existed, all that sort of thing. The arbitrator would decide all of that. So there's no question that in this particular case, the arbitrator had the power to decide the arbitrability issues. And in fact, they even say it in their brief. They say the arbitration clause in the ACAF specified arbitration administered by JAMS pursuant to its streamlined arbitration rules and procedures. Rule 8B provides that jurisdictional and arbitrability disputes shall be ruled on by the arbitrator. So once the arbitrator has ruled on those issues that are within his power to decide, the court cannot reconsider the merits.
Do you cite any cases to us saying that that sort of incorporation by reference is enough to show an agreement?
There are multiple cases in
I think there are cases out there. I just didn't see them in your brief. I thought you cited Henry Schein.
yeah, we did. We cited a number of federal cases and I believe, let's see. We did, Your Honor. We cited a number of circuit court cases and including a couple of cases from the Fifth Circuit, I think a case from the Ninth Circuit. And it's footnote 8 on page 14 of our brief. It cites a number of the cases which holds at the incorporation. And I would just suggest that in this particular case, there has been no contention that the standard in first options was not met. That there's clear and unmistakable evidence that the parties agree, because they've stipulated that the parties agreed to JAMS Rule 8B.
As far as a remedy or conclusion or relief that you're seeking here, what are you suggesting? That you're asking the court to affirm the confirmation of the arbitration award below?
Right.
And what about what, if anything, should be said about the district court, federal district court proceedings and the DC Circuit decision vacating the judgment there?
I don't think you say anything about that, Your Honor, because it has no impact whatsoever on this case. Yeah, it's obvious that, people might raise knowing that that judgment's been vacated, not knowing about the monetization portion, that people might just naturally assume that there's no contingent fee to be paid. That's wrong. But so I understand where the question is coming from. But at the end of the day, the DC Circuit's opinion has no effect at all on this case. It doesn't affect what is and is not arbitrated. It does not affect the portion of the award relating to application of the allocation to the contingent fee. It doesn't affect anything.
Is there any reason that the monetization of the award wasn't raised sooner?
I can't speak for them, Your Honor, because it was never an issue for anybody until 2 weeks ago.
It was never an issue, meaning the fact that the award had been monetized was never an issue.
Right. Right. And it's like I said, it's reflected in the judge's order. I mean, in the arbitrator's final award even. And we've referenced that in our responsive brief.
It's reflected explicitly, or it's implicitly reflected?
It doesn't tell you what the numbers are, but it does tell you that the monetization occurred. And we've cited several different pages in the brief. And the reason that it doesn't reflect what the numbers are is we have confidentiality agreements that we have to respect.
Any further questions? All right, thank you.
Yeah.
Counsel, you have reserved 3 minutes for rebuttal.
Yes, thank you, Judge. The first point I'd like to make is that, perhaps one direction this place, the court may be going is if the monetization is recognized, which we dispute as being from or on behalf of Iraq, but if it is, then I think the court needs to take consideration of the fact that despite what counsel for Al-Pali said, QRG never said that they agreed to a 0%. What QRG did on ethical and jurisdictional grounds was not to assert its entitlement to a share of the contingency fee in the arbitration. It was not a concession that it was not so entitled. And even the arbitrator recognized that. For that matter, Judge Lamberth, in deciding on the attorney fee petition, because he had decided to award attorney's fees against Iraq, recognized that QRG was entitled to over $1.7 million, representing the legitimate fees that he found to be reasonable and necessary in connection with QRG's efforts in prosecuting the WIOC litigation. So QRG's efforts were not insubstantial. The fact that it did not get a percentage was because it did not assert a percentage on ethical and jurisdictional grounds. The ethical ones where it saw a conflict with its own client, with WIOC, in doing that. So I don't think—
So in your earlier argument, you expressed, and I don't want to put words in your mouth, so correct me if I'm wrong, but you seem to express surprise or lack of awareness of anything about monetization. And so, I mean, was your client aware of the monetization during the arbitration proceedings?
We were generally aware of monetization. I don't know. I did not represent QRG in the arbitration itself. I became involved in the course of the initial appeal in this case. But we certainly during the course of the legal proceedings in this court and the Superior Court, we were aware of monetization. We deferred to Whiteford Taylor to a large degree because of the confidentiality issues that we were not privy to. So it was only a general understanding without real, details.
Right, but there was, so at that point, when you became a client, when your client became aware of it during the arbitration, you would agree there was no, assertion of, stop the presses, we've got a different landscape here.
Well, I think that the different landscape occurred when the Supreme Court denied the petition for certiorari and the Iraq litigation. And that occurred after the main briefing, round of briefing, I believe, in this case.
Well, no, but I mean, I guess my point is there was no claim that the arbitration, the agreement to arbitrate was somehow affected by a decision to monetize at that point. It seems like your client thought that the situation was the same, whether the amount was going to be $120 million from Iraq or some smaller amount based on a monetized.
I don't know that they took a position one way or the other on that issue, Your Honor.
Well, opposing counsel or counsel for WTP, I was understanding to say that QRG, all these initials, agreed to give up one of its tort claims at least during arbitration because of the understanding that there was a monetized award. Did I understand that correctly?
He was saying that his firm, Whiteford Taylor, agreed to give that up, but our view is that all three of the tort claims fall outside the scope of the ACAF, as we set out in our briefs, because they all, and the arbitrator himself described the grounds for his award of tort damages. And it's in the final award. The pages are cited in our briefs, but they were all about things that occurred long before the formation of the ACAF itself and had nothing to do with the ACAF at all. So, our position on the tort claims is that they clearly fell outside of the scope of arbitrability in this case.
Anything further? All right, we thank all counsel for your briefs and arguments as well as for your supplemental briefing, and we'll take the matter under advisement. Thank you. Our second case this morning is Jorge Alexis Camacho versus BREESE Janice EDDY.
It's live.
All right. Is counsel ready to proceed?
I'll reserve 2 minutes.
You can adjust the podium if you need to,
Bring it down.
and if you could pull the microphone closer and state your name, please.
Thank you, Your Honor. Rebecca Sullivan on behalf of the appellant.
All right.
May it please the
You wish to reserve 2 minutes, you said?
Yes, reserve 3 minutes. Thank you, Your Honor. And I thank the court for their order yesterday instructing us to be prepared to talk about whether summary judgment was pled with respect to the September 2024 motion. I was not trial counsel, but I did have the opportunity to consult with trial counsel on that issue, which was very helpful. So I think there are a couple paths and they both lead to the same place on this issue. On October 1st, 2024, the appellant filed a motion with a compound title, which was a motion to modify and a motion to enforce in the same title. That was served on the appellee, but it was rejected by the clerk, by the filing clerk, for having a compound title. So the next day, August 2nd, 2024, appellant refiled the same motion with a different title, motion to modify legal custody. So then when the appellee moved for summary judgment, she actually used the title of the August 1st, 2024 motion that was rejected, the compound title of motion to modify legal custody and enforce the marital settlement agreement. But the whole substance of that motion relates only to that August 2nd, 2024 motion to modify legal custody, not to the September 2024 motion to enforce. And the appellant filed an opposition accordingly, only on the substance of that August 2nd, 2024 motion, not on the September 2024 motion to enforce. Judge Wellner, the trial judge, never saw the August 1st, 2024 motion with the compound title because it wasn't filed, and he only saw the docket, not what was served. So Judge Wellner reasonably inferred that the motion for summary judgment related to both motions, the August one and the September one, when in fact it only related to the August motion.
Shouldn't we be looking at the motion for summary judgment?
At the motion,
Figure out what the judge thought? I mean, the motion for summary judgment is a motion for summary judgment on the motion to modify.
the motion for summary judgment is only on the motion to modify that was
Mhm.
filed August
So
2nd,
the
2024. Exactly.
Court didn't have a motion for summary judgment on the motion to enforce.
That's exactly right.
Okay.
But he didn't think he was acting I assume, I infer from his words, he didn't believe that he was acting sua sponte in granting summary judgment on the September 2024 motion. Because from what he was looking at, I believe that he perceived he had both motions in
And I
front.
appreciate your efforts to defend trial court, but you're looking back to the initial motions to modify and motions to enforce. And he had one summary judgment motion in front of him, and that summary judgment motion dealt only with the motion to modify.
That's exactly right.
So,
That's exactly right.
but do you have anything else to say on that? I think we get your point.
Yeah,
Do you want to move on? Should we talk about the motion to modify?
Yes, absolutely, Your Honor. But ultimately, I think it doesn't matter because this court reviews substance and procedure of summary judgment de novo. So I think the court stands in the trial court shoes and can
Well,
find.
it could matter. I mean, if the court granted summary judgment on something that it didn't have a motion to grant summary judgment on, that would seem to be an automatic reversal.
I think
Unless you could show harmlessness.
unless it was harmless. And to discuss harmlessness, we look at the viability of the claims. And I think that's a very similar, possibly the same inquiry the court would look at to decide whether he erred in granting summary judgment substantively.
On the motion to modify.
On the motion to modify,
Okay.
exactly, Your Honor. So focusing on the motion to enforce, it comes down to contract interpretation, which of course this court reviews de novo as well. Whether, particularly looking at.
I mean, this is just getting to my point about summary reversal. I mean, if you have a contract term where one party is saying it means X and the other party is saying it means Y, and the court is acknowledging at the November hearing, and I think at the December hearing, I might have to take evidence about what these parties thought this meant when they signed the agreement. And then the court just doesn't get that evidence, doesn't take that evidence, and then purports to decide not what the term means, but what it doesn't mean, then isn't that reversible error?
I think it is reversible error. I don't think the trial court said he needed evidence. I think everything else Your Honor just recited, he did say. He said, I don't know what this means, but I know it doesn't mean X. And X is exactly what we think that it says. And I certainly may be remembering what the trial court said, but I don't think the court took or said that it needed evidence of the party's
I mean,
intention.
at the November hearing, he said, this seems like an open question. I might need to hear from the parties about what they were thinking at the time, right?
Yes.
I don't know what this, I'm not saying how this would come out. I haven't heard any evidence. There might be factual issues about what the parties were thinking about the time. You know, what did the agreement mean?
Right.
Right.
But then he changed course a bit before when he granted in the next hearing, when he granted the summary judgment, that's when he says, I don't need evidence. I know what this doesn't mean.
Do you think that the court had determined that the language was ambiguous and then decided what it meant, notwithstanding the ambiguity on summary judgment? Or do you think the court determined that it was not ambiguous and it could determine what the language meant or didn't mean under its plain language?
I think the court wasn't clear about that, and I think that's part of the error that I think was made in that oral ruling, is that the court never said what it thought the language meant. It said, I think it's something in the ballpark of conflicts of law, maybe jurisdictional, but the court never said it unambiguously is this. It just said, I think it's unambiguously not a prohibition on what happened.
Are you suggesting then that it should be reversed because the judge made an error of law, or that it should be remanded so that there can be a hearing on all of the issues and facts surrounding that legal issue?
I think it should be reversed because 2.1G unambiguously says that a party cannot move the children's primary residence to outside of the District of Columbia.
That seems like a difficult position to take because there are ways that you write any relocation provisions. And this is not written like a typical, it doesn't say the mother shall not move the children out of the District of Columbia. It talks about home state. It's using this language that seems to be borrowed from these different contexts of the Hague Convention and the UCCJEA. So at the very least, it seems like there's ambiguity here. So that would, point in favor of a remand for the court to do the thing that it should have done, that it skipped over because it thought it had a summary judgment motion in front of it that it didn't have, arguably. I mean, we'll hear from the other side. Maybe they have a different position, but, and if that's the way this is looking, my question to you is, to what end? What's the end game here?
Right. Well, I don't think.
Setting aside the motion to modify,
Right.
hypothetically, for the sake of argument, let's say we are not persuaded by your arguments about the motion to modify, but we do think there was a problem with this motion to enforce. What is the point?
So then I think the remedy for the trial court is enforcing, if your honors find that it's ambiguous, but enforcing
enforcing the anti-relocation provision 2 years later after they've moved.
Yes.
I think the judge has the authority and the power, and that it would be in the best interest of the children. I mean, I don't know, the court could take evidence, but 2 years in to say, no, now you have to take these kids out of their school and you have to move them back into the District of Columbia?
Absolutely.
And the court can't send them back to Shirley Chisholm. They've aged out of elementary school.
And that is the problem with this case and every other case where people act first and ask forgiveness instead of permission, is because what happens is mom takes the kids out of school and then says,
I mean, I hear you, but if we think that this is an ambiguous provision, so it's ambiguous, and so she thought it meant one thing and she was wrong, then this isn't like she was willfully violating the agreement. It was, she really thought it meant one thing and she was standing on her rights and as sole legal custodian, and she moved them to Virginia and to a different school, as was, she thought her prerogative. She was wrong. You really think that the remedy, I mean, maybe attorney's fees or something, but really, I'm struggling to see what your client is looking for here.
So two responses. And first of all, she did not think that she had the right to move them to Virginia. She thought the provision was unconstitutional at one point, and she asked for mediation to modify that provision.
I don't know what evidence you have of that. I mean, I'm looking at the record and it seems like she is saying, starting in January, this is something that I want to talk to you about. And your client shuts her down and doesn't point to the marital settlement agreement, points to some parenting plan.
The parenting plan is part of the marital settlement agreement.
okay, but he doesn't point to 2.1G. I mean, maybe he's talking about, you know, the custody arrangement of shifting back and forth. But it's just like, there's no evidence in there that she knows that she is violating. And if that's your argument, I think you really have a difficult road ahead of you. So-
There are emails from her counsel where they say, we want to go back to mediation to
Sure.
modify
They
the parent.
want, I mean, and your argument is then she's not meaningfully consulting with us, but she's also trying to say, hey, you have concerns about the move. Let's renegotiate the parenting plan. That's fine. I thought the parenting plan was something that the parenting coordinator helped to draft. That's not right.
It's a reference to the portion of the marital settlement agreement that deals with custody. That's often referred to as the
Okay.
parenting plan.
So the whole custody portion of the marital settlement agreement, all of section 2?
1 and 2. 1 is legal custody and 2 is physical custody.
Counsel, so just as a process matter, though, if essentially what's a contract claim, a motion to enforce an agreement is brought as part of a child custody case, and suppose there's basically a breach of contract, we agree with you on the motion to enforce aspect. Is it the case that, again, in the context of a child custody case in this division of Superior Court, that the court would still proceed to the modification question, which is material and I don't have the exact language, sorry, material and
Substantial,
substantial, right? That the court would proceed to that anyway to determine what the remedy for this breach, essentially a breach of contract, is.
Yeah, so this agreement, the marital settlement agreement was incorporated into a court order. So it's both a violation of a court order and a breach of contract are the remedies. And then, yes, there's case law, and I think that case law can and should be expanded on, that says that repeated violations of a
It's
parent.
never argued in the trial court.
But I'm saying that in this case, suppose the court had said, this is a relocation provision and it was breached. I know that's not what happened, but let's say that happened. What would the court have properly done next to determine what the remedy was? Would it not still have proceeded to the modification standard?
Could do both. It can enforce the marital settlement agreement. So if the court found that this was an anti-relocation provision, the court could have enforced that and then heard evidence as a relocation case. Mom would have had to ask for permission to relocate, to modify under Samuelson and under the 16914 factor.
I'm saying that the court would not have been required, at least, to say breach of contract, remedy is unwind all of this, you have to move back right away. It would have been, it's at least within the court's discretion to say, I still need to go through the material and substantial change in best interest of the children analysis.
The court could have gone that way and found that the change was a substantial material change of circumstances,
Or
but the
not.
court also could have just enforced. It could have modified or enforced.
Right. So I guess
Yeah.
going back to Judge Easterly's question, at the end of the day, what happened? I mean, the court did that. One of the two avenues that you said is permissible, which is to say, I mean, it didn't say that this was a violation of the relocation provision, but if it had, it still would have gone on to decide that I'm not having this family move back to the district at this point when they're already in school.
Right, and I think that that was inappropriate for summary judgment because there was no evidence about any of the factors of 16916 or Estepina or Samuelson that the court should have considered in granting summary judgment on a modification of custody, which is just rarely appropriate given all the things.
It didn't put any evidence in to dispute the facts, right? The motion for modification was based on the move and the decision to change schools. That's what was in the motion for modification. Your client put in no evidence that the move affected his physical custody of the children or their relationship with him. It made no argument about that. It was all about the schools. And so then as for the schools, Ms. Eddy put in evidence that, I mean, his whole argument was, I want them to go to a bilingual school. And Ms. Eddy said, look, the children are bilingual. They are fluent. They have Spanish speaking care providers. They spend time with their father. He can enroll them in other, bilingual education opportunities. And he put in no evidence to say that's not enough. They have to go to a bilingual school. He just said it in his legal papers, but there was no expert reports or anything. I mean, he didn't contest those facts that I just recited to you. And he didn't put on any evidence to say this is going to be detrimental to them. And I know you're saying, well, this was decided on summary judgment, but to oppose her motion for summary judgment, he had to bring forward his evidence to show there's a disputed issue of fact here. And I looked at his opposition to the motion for summary judgment just this morning, and I don't see that.
He did dispute many of the purported undisputed facts.
I
right?
agree he disputed them. I
And
disagree that he actually put forward evidence that called them into dispute. And I think under our case law, that's what is required.
I think he was expecting, I think his counsel was expecting an evidentiary hearing where all that evidence and those arguments could
Right,
come
and you get an evidentiary hearing, I think, if you show that you have things to present at an evidentiary hearing.
Right. And I think they disputed enough facts in their opposition that should have got them at least to a hearing where he could have put on evidence of all those things.
So
I
you're
think-
saying he should have had a hearing where he could have put on additional evidence, but that we should vacate the trial judge, that we should affirm the trial judge's order on enforcing the agreement?
Not affirm. I think the trial judge granted summary judgment on both motions in favor of the appellee. So I think that as far as the violation, we're asking for a reversal, that this court find that 2.1G is an anti-relocation provision that was violated. With respect to the modification, we are asking for a remand so that the court has an evidentiary hearing on the
I
modification.
almost thought it would be the reverse, that you want a remand on the enforcement issue to put forward evidence. But let's talk about the modification a little bit. The trial judge relied heavily on the Bilta case where the one party moved the children out of the DC, close DC, DMV area to Severna Park, Maryland, much farther distance than the children were moved here. And there was a disruption in Bilta with respect to the children's visitation with the other parent. We don't have that kind of disruption here. The visitation continues. So I guess what would be your basis of contesting the modification decision by the trial judge?
In Bilta, this court affirmed on the abuse of discretion standard. And it's very possible that if the trial judge in Bilta had gone the other way and found that it was a substantial and material change of circumstances, this court would have affirmed that as well on the abuse of discretion standard. So I don't think that Bilta sets a floor. I think that it is, one data point of where the court is affirming discretion of the trial court. But Bilta was different because the children did not change schools. And the parents in Bilta had a 50-50 custody schedule. And the trial judge in that case found that this child's connections to DC, the Columbia Heights community, the bicultural aspect of that family would remain intact because it was a 50-50 custody split.
But again, here, the mother had full custody. And so to me, that further distances it from, that distinguishes it from Bilta, and also lessens in many ways, one could say, any disruption to the children. She had full custody, not 50-50. They didn't move that far. They're right in the what we consider to be the DMV area. The visitation schedule remained the same. So I guess what would be your basis for refuting the judge's decision with respect to the modification agreement? Particularly where the judge here goes on to talk about what he viewed as the best interest of the child.
I do think that Mr. Camacho should have had the opportunity to be heard on this, to have a hearing on this.
He asked for a hearing? I looked at his opposition. I don't see that he ever asked for a
The
hearing. He just-
proceeding does not say that he asked for a
He,
hearing.
he just asked the court to deny the motion for summary judgment.
In his opposition, yes, he did not ask for a hearing.
He didn't
specifically,
say,
no.
I have evidence, please give me a hearing. He didn't cite evidence in his opposition, and he didn't ask for a hearing in his opposition.
I think asking a court to deny summary judgment is effectively the same as asking for a hearing. It's asking to move forward to be able to put on your evidence.
So with respect to my question,
that's
the
not- I
harm
thought
was
you-
not having the hearing, is that it?
Well, there's other harm too that, for example, one of the provisions, Mr. Camacho is not allowed to take the children more than 60 miles from mom's home, right? So when mom moves, that changes it for him. A lot of the exchanges take place at mom's home, especially in the summer. So now dad has to drive to mom's home.
Yes, but I thought the evidence was that mom's home is actually closer to him now post-move, and he did not dispute that.
One concern with that is these incremental moves and
I
that.
understand that, but I'm just trying to focus on, we're reviewing what the trial court's ruling was on the arguments that were made to the trial court. And there just seemed to be a lot of sort of after the fact arguments being made on appeal. I just wanted clarification on the hearing. So you were saying, I thought you were saying he should have had a hearing on whether summary judgment should be granted. But you're saying he was just entitled to a hearing, an evidentiary hearing on his motion.
That's what I'm arguing, right?
So
He
he didn't ask for but once somebody moves for summary judgment, if you want to oppose summary judgment and say, I've got evidence supporting my opposition for summary judgment to show their material disputes of fact, shouldn't you ask for a hearing on that?
He did not ask for a hearing on that. But he did in his opposition say these facts are disputed.
He said it, but he didn't put forward any evidence in support of that. He didn't he didn't cite to affidavits from anyone. He put forward lots of emails from 2017 and 2019. He put in some letters from counsel. Actually, I think one of the letters from counsel actually supports Ms. Eddy and shows that they were talking about the schools, because his lawyer says his big concern is about the school change, and that's before mediation. So I just don't see the evidence that he puts forward that creates a dispute of fact about the motion to modify.
Well, I don't think that he needs to support himself. It's a verified pleading. He did sign the pleading, so it's his own verification, I believe. But I don't think that there were other affidavits that he would have, or expert reports that he would need to attach. I think he's consistent with Rule 56. He's saying we don't agree to these facts, and we should, be entitled to move forward with an evidentiary hearing to prove whether these facts are true or not. And I think that he's entitled to do that in a substantive hearing on his motion to modify and his motion to enforce, rather than needing that to be a summary judgment hearing standing alone. Nothing further?
Thank you. We'll reserve your time for rebuttal as well.
Good morning, Your Honors, and may it please the court. My name is, excuse me, Elisa Yassin, and I represent the appellee, BREESE EDDY, who is present here today in the gallery.
Right,
I
good
also
morning.
wanted to start with addressing the court's order issued yesterday regarding the scope, so to speak, of Ms. Eddy's motion for summary judgment and whether she moved with respect to both the August 2024 motion and the September 2024 motion. And while Ms. Eddy concedes that her motion, which is broadly titled Defendant's Verified Motion for Summary Judgment, in its preliminary paragraphs only speaks to the first August 2024 motion, which is the one I would note is the one that was personally served on Ms. Eddy, the one with the joint title, Motion to Enforce and Motion to Modify, which is why that was the one that was opposed and responded to on the trial level by Ms. Eddy. It also addresses both issues because all of the issues in both motions spring from the same underlying facts and
Just don't
contentions.
see the motion to enforce. I don't see an argument in there, particularly as to the meaning of 2.1G, the provision. Like, they've talked about this at the two hearings where the court has said, you know, okay, focus on what this language means. And Mr. Camacho has said it's an anti-relocation provision, and Ms. Eddy is, or through counsel, has said, look, it's using language from the Hague Convention and the UCCJEA, and we were concerned about absconding. And the court says, I think I might have to take evidence about what the parties thought about this, right? Like, they've talked about this. It is teed up. And there is no place in this summary judgment motion where Ms. Eddy says it is totally clear from the evidence that this is what this provision means. It's just not in there.
I don't disagree with you, Your Honor. I think the pieces of the motion to enforce that are addressed in the motion for summary judgment are the pieces that relate to the question as to whether or not there was meaningful consultation around the various issues. Ms. Eddy's move,
I mean,
the school
it's
choice.
sort of more, that's more complicated because it just feels like nobody kind of knows where to put the meaningful consultation conversation to start with. I mean, it's in the motion to enforce, but the prayer for relief in the motion to enforce is not make her meaningfully consult with me. It's, you know,
That was part of
it isn't. I mean,
I believe so.
maybe, but like, there's no dispute about, like, nobody's saying the parties are fighting about what the meaningful consultation provision means. Like, it's all backward looking, I guess. And it seems to kind of fold into the motion to modify because the court is the one that says, I think in December, says, you know, look, I don't see a change in circumstances based on the move. I don't see a change in circumstances based on the school change. Maybe you could make an argument about a change in circumstances because she's not meaningfully consulting. Like, the court sort of pulls that into the meaning. And it seems like that's what the summary judgment motion is talking about the, well, there's no, you know, change in circumstance based on a failure to meaningfully consult.
And I think that's in part because at that hearing, when we had initially scheduled the June 2024 hearing, or excuse me, yes, 2024 hearing, 2025 hearing, the court had indicated that he intended to bifurcate that proceeding. And he had indicated that he intended to address initially whether or not there was a substantial material change of circumstance warranting modification. And if so, then whether that change was in the children's best interest in step 2. And so he had sort of outlined it at that hearing in terms of how it was going to proceed. And so then in addressing him on summary judgment, we addressed primarily, as the court notes, the request to find a substantial material change in circumstance, because based on the idea of bifurcation, if he didn't prove a substantial material change of circumstance, there was never going to be a step 2 best interest analysis, and we weren't going to need a
Precisely, but where does that leave you on the motion to modify on the, or the motion to enforce what Mr. Camacho, sorry. Where does it leave you on the motion to enforce what Mr. Camacho was calling the anti-relocation provision? It just, like, that is.
I'm happy to address
does
that, Your Honor.
not seem to be, the court purported to grant summary judgment on that, and there was no summary judgment motion before the court on that.
Well, and to jump to the third question the court asked, is there, if he committed an error, whether it was harmless, that would be our position. Is that to the
Can
extent?
you say that's harmless if it's an ambiguous term and the court itself acknowledges that under contract law, if you have an ambiguous term, you have to figure out what the parties meant by it, and then the court has to make a ruling about what the language means, and the court never says what the language means. This court says, well, I know what it doesn't mean.
I believe he says that it's a jurisdiction or a conflict of laws provision, and he adopts essentially the position Ms. Eddy took in her verified opposition to the
Okay,
motion to enforce.
say I agree with you that he is super clear about that, but I'm not so sure. Is that legally correct for the court to make that determination without taking evidence from the parties about what they were thinking at the time of the formation of the agreement? Like, I just don't know that there's cases out there that just say, oh, well, a court can identify an ambiguous term and just decide for itself what it thinks it means without, it's a contract.
I think
We
he
need to
didn't
know
have
what
to
the
get there
parties thought.
because I think he ultimately determined it wasn't ambiguous. And we only get to extrinsic evidence under the applicable case law in this jurisdiction if the court finds it to be ambiguous.
Okay, then
he-
it seems a really hard argument for you to say this isn't ambiguous.
I don't believe
I
it is
mean,
ambiguous, Your Honor. When we look at it, and I think, in fact, appellant cited to the Tillery matter, which I think really helps address this issue as to why it's not ambiguous. The terms home state and habitual residence, just like the terms legal custody and physical custody, are terms of art that are used within the custody context and are
But they don't
understood.
make any sense in this context, right? And so
They,
it's a weird thing, like, sure, they're terms of art. I grant you that. But it just seems very strange that they've been used here. And as the court itself said, I think at the November hearing, if I'm a layperson and I'm reading this, it sure sounds like this language means the kids have to stay in DC.
I don't think it's strange that they were used here when you look at the extensive contentious background of this case, which the trial court had the benefit of being the trial court during the initial phase as well as post-judgment.
That may be true, but it just seems like there needs to be evidence from Ms. Eddy talking about, this is what was in my head when I agreed to this.
How do you respond to the opposing counsel's claims that Ms. Eddy actually did understand this to be an anti-relocation clause?
I believe this is information that's outside the record evidence, but I can address it because I've been Ms. Eddy's counsel through all of these proceedings. And what I can tell the court is that when that was something that was raised with the parent coordinator and Mr. Camacho's former counsel, Ms. Eddy was contemplating a move much further than where she ultimately moved. She was contemplating moving out further into Virginia, perhaps Fairfax or the like, and ultimately decided to only move 10 miles from her prior residence, which had, as the courts noted, no implications for Mr. Camacho's ability to spend time and to continue to have the same physical custody arrangement. Whereas if she had moved somewhere that would have perhaps resulted in an hour or more commute, it would have had various implications and we would have had to perhaps seek permission and from the court if he didn't consent under the BILTA and the Estepina factors.
You talk about BILTA, but there are some key differences in BILTA, particularly with respect to the language in their custody agreement. In BILTA, both parties state in the agreement that they intend to live in or near the District of Columbia. But here, the language in the marital separation agreement just says the District of Columbia, not just near DC. And then it says shall habitually reside in the District of Columbia. So it doesn't, if you look at it on its face, doesn't seem to lend itself to the interpretation that only 10 miles away is not really a big deal under this language.
Well, the language, our contention is 2.1G is a jurisdiction provision, which when it states District of Columbia is and shall be the minor children's home state and habitual residence, that relates to the establishment of the jurisdiction at the time of the agreement, which the trial court, not just this trial court, but most of Superior Court trial court, particularly in cases where there are concerns about abscondence, which there were at the time in 2017, 2018, when this case was first before the trial court, has concerns about. They often make statements and even their custody orders stating the District of Columbia is the minor, shall be the minor child's home state. Perhaps they use.
But all of this strays from your point 2 minutes ago that this is plain meaning, a plain language interpretation, and you're bringing in extrinsic, evidence about the party's intent and the party's understanding and the background of the negotiation of the contract that would only come into play if the court had deemed this ambiguous.
I'm not meaning to bring in the background of what was in their minds or what their understanding was as to when they signed it. I'm saying, as it is in this agreement, it is a jurisdictional provision because it uses these specific terms of art that are defined. And Tillery makes clear in the footnotes that when you look and it doesn't make it ambiguous. For example, if a term of art in the context does not create ambiguity when both parties agree that the term is used to describe the specific issue. And here, the term home state, for example, is defined within the DC code and UCCJEA.
But both parties don't agree. right? I mean.
But they do, and that-
Hillary,
Mr. Camacho used that same phrase himself repeatedly in his pleadings prior to signing the marital settlement agreement. And while I understand that that is then to look at to the extrinsic evidence, the trial court, as I said, he was the same judge both times. He had understanding and knowledge that that was something that had been stated and pled multiple times by the.
But even
Appel-
if you're right about the reference to the Hague Convention, I mean, for the habitual residents to be in DC, then at a minimum, the children would have to live in DC.
Well, I think that the Hague Convention language is a red herring, and you know, the trial court says he doesn't know what to do with it. Whether the children lived in the District of Columbia or Virginia, it doesn't matter because the United States of America is the habitual
Right,
residence.
but it was you and your client who's saying that it was used because of the Hague Convention and concerns about absconding. And so
Because
if-
there was concerns that Mr. Camacho would leave the United States.
Right, I understand. But if the point is that, and none of this really makes sense because as you said, the Hague Convention refers to the nation and not to a particular place. But at the very least, if the intent was that the habitual residents would be in the district, then at the very least, the children would have to reside in the district.
And they still do with Mr. Camacho. And the District of Columbia remains their home state because DC continues to have exclusive continuing jurisdiction and is still considered their home state because Mr. Camacho remains in the district and they spend time with Mr. Camacho in the district. He doesn't have 50-50 custody, but he does have overnight time. He has 4 out of every 14 nights with the children. And so we don't also believe she's violated it because we are not contesting that the District of Columbia remains the children's home state.
And they're habitual residents? I mean,
I think, again, I think the application of habitual residence to the District of Columbia is less applicable because they still remain in the United States of America, which is their habitual residence.
So here, the trial judge went on to talk about the best interest of the children, ultimately concluded that no modification was justified because where they are is in their best interest under these circumstances. What, if anything, does the trial court's best interest of the children assessment, what, if any, impact does that have on the initial question about whether or not there was a violation of the agreement or the motion to enforce the custody agreement?
I think the trial court spoke to this issue in the November hearing as to whether or not there was a violation. And I believe he indicated, and I'm paraphrasing because I don't have his specific site in front of me, that even if she had violated, that didn't necessarily mean that the remedy was for him to order. In fact, he notes he doesn't believe he can order. And our contention is he cannot order her, Miss Eddy, back into the District of Columbia. And therefore the remedy would be for him to then essentially change the custody arrangement and to provide for the children to live primarily with Mr. Camacho in the district. And Mr. Camacho, in response to that, counsel, specifically stated, so the trial court said, the ultimate question of sort of to what Judge Easterly asked opposing counsel, what do you want to do here? I mean, if the other outcome, that seems unlikely, just given where everything is and has been. It does seem unlikely that the rest of a trial would be, the kids would be living full-time with Mr. Camacho and that Miss Eddy would have no involvement in making any decisions. And trial counsel's response was he's not seeking that. And that's a joint appendix 277.
I mean, they only ever asked, he asked for sole legal custody.
As for joint with tiebreaker.
Or sorry, joint with tiebreaker, but he never asked for sole physical custody.
He made zero requests in terms of modification of physical custody at all, which begs the question of what the purpose, as the court asked, is all of this in the first place? Because I see very little issue of whether she lives 10 miles across the river in Virginia versus in her little former apartment in Southeast DC to their ability to make decisions together. She could have moved 10 miles to the other side of DC. She could have moved to Upper Northwest. She could have moved to Northeast. She would not have had to seek his permission. And she could have also changed the schools pursuant to that after she engaged in meaningful consultation. the issue here is simply that when Miss Eddy does not agree to what Mr. Camacho wants, he takes issue with that. And the record is replete with that. In fact, the trial court clearly noted that that's the furniture of the case here. Mr. Camacho's been complaining about the children's school placement and Miss Eddy's decisions since before he entered into the marital settlement agreement in October of 2017. But nevertheless, despite his complaints about her choices related to children's schooling, he ultimately vested her with sole legal custody, which the trial court notes correctly. And so, you know, it's not like our other case law in this jurisdiction, Galbus, and the other cases that appellant cites about multiple violations that then would warrant a change in custody. I mean, first of all, we don't typically change from sole back to joint. It's usually the other way around, where continued conflict leads us from joint to sole. So here, there's this remedy of changing it from sole to joint on things that were known and foreseen, which Rice, Graham, and all of the other progeny make clear the change had to have been unforeseen. He doesn't meet his burden. And that is, I think, the crux of the issue, is that he provided absolutely no evidence, and the burden shifted to him under our summary judgment case law to prove something that would show disputed facts. And I think Judge Easterly was also getting to that in her questions earlier, in terms of, in his opposition, he provided no evidence, no affidavits, nothing to find that there were actually disputed facts that would have led to a dismissal of summary judgment.
Do you agree with Ms. Sullivan's argument that it was enough that his opposition to the motion for summary judgment was signed by him? Does that?
I think that's all he had. I don't think he had
But
anything.
I think her point was it sort of converts it into an affidavit, and so everything is sort of sworn and should be received as evidence. Is that enough to survive a motion for summary judgment?
I think that I agree with Ms. Sullivan that a verification on a pleading converts it into being understood to be an affidavit. I think that his sworn statements were not sufficient to move the burden, because what he disputed were not significant enough issues to show that there was a true material issue of fact. And he pointed to no, he had the ability to provide other evidence. I just wanted to address one other issue about whether the court had the authority or ability to rule on summary judgment on both motions. Under Rule 56, I believe F, the rule states that after giving notice and reasonable time to respond, the court may grant the motion on grounds not raised by a party, or consider summary judgment on its own after identifying for the parties material facts that may not be genuinely in dispute. And I would note that a week before the hearing was held, the court issued a scheduling order on October 3rd, 2025, which is reflected in the docket, which is at Joint Appendix page 2. And in that order, the trial court clearly and unequivocally stated that all four motions appear to cover a similar set of issues. So counsel must be prepared to address any of the motions if the court finds that hearing from them at this hearing will facilitate their prompt resolution.
Which hearing was that? I'm sorry, I missed.
That was before he issued his oral ruling in April of 2025. He issued that order on April 3rd.
Right, but I don't recall that the court invited further argument from the parties before he ruled. Did he?
After he ruled, he opened it up for any questions, and Mr. Camacho's only question through counsel was, is a written order going to issue?
Right, but and that's after he ruled. I mean, it just yes, courts can grant summary judgment sua sponte, right? After giving notice. And this is sort of this weird situation where the court raises the issue of summary disposition at the December hearing and identifies the motion to enforce as a possible ground that it could grant summary judgment on, but then sort of backs away and says, but maybe I need to take evidence on what the parties were thinking. And then one of the parties, you, moves for summary judgment and only moves for summary judgment on a subset of issues, doesn't include this, how do we interpret the provision that's being, construed as an anti-relocation provision by Mr. Camacho. And so, then for the court to resolve that question sort of in the negative, it doesn't mean that. I just don't see how that's compliant with Rule 56F.
Yes, and so the reason I believe it's a harmless error is because the court could have also just denied his motion to enforce on the papers. He ruled on all 4 motions at that hearing. He also denied the subsequent motion for appropriate relief, which was filed after we had moved for summary judgment and after the opposition had been filed. He also disposed of that day. And so the court was within his authority to dispose of all of the motions. They were all ripe. They had all been properly and fully briefed. Mr. Camacho had had opportunities to file any replies that he might have had to the oppositions to the motion to enforce, to the motion for appropriate relief. The court made clear by providing his notice that he was planning to deal with all of those motions. And so they were all ripe for review, whether he granted summary judgment on the motion to enforce or whether he denied it on the papers based off of after he had made that consideration. I think the result ends up being the same in that his decision was that he didn't find she violated it and wasn't going to enforce it and denied the request.
Thank you.
Thank you, Your Honors.
All right. Yes, Sim?
Thank you. I wanted to hone in on the difference in the UCCJEA between home state and continuing exclusive jurisdiction. Because the language in this MSA, the parenting plan portion of it, talks about home state. It doesn't talk about continuing exclusive jurisdiction. Home state is defined in the UCCJEA as the place where the children have lived for the past 6 months. It's where the children physically live. So even if this is a reference to the UCCJEA, it's referring to home state, which is where the children live. It has nothing to do with where the other party lives, significant connections, or how far away it is, which are only relevant to continuing exclusive jurisdiction, the jurisdictional piece. There's absolutely no way to interpret habitual residence as referring to the Hague Convention on the civil aspects of international child abduction. It's an international treaty, federal law, primarily litigated in federal courts. It deals with disputes among nations. There's no reference in the record to the Hague Convention until the opposition to the motion to enforce is filed in September of 2024. There's no evidence, and maybe
Why would there be any reference to it before then?
there's no reason to think these people had any idea what the Hague Convention was, right? Maybe they did, maybe they didn't. Maybe that's an issue for an
I mean,
evidentiary
it just
hearing.
seems like we don't know because these terms in this context were ambiguous and no evidence was taken about what the parties were thinking.
But I would say for the Hague Convention as well, even if like, somehow these people are referring to this treaty, right? To be a habitual residence, the kids still have to live in DC. And habitual residence under the Hague Convention is a backward-looking inquiry. So they also use the words and shall.
Why does habitual have to mean you have to live there? I mean,
That's
might be a habitual runner. That might mean I run every 6 months, right? Like, I don't know what habitual means. So I don't know what they thought it meant.
residence, I think we all know what a residence means, right? And there is federal law. There's a recent Supreme Court case interpreting habitual residence under the Hague Convention, if that's the direction we're going, that defines it as the not only the place where they live, but the place where they're integrated in the community, where their activities are, where a fact-based holistic inquiry into where they are integrated and residing.
And therefore, you're contending that these terms were ambiguous in the Marital Separation Act, or that they were not ambiguous, or I'm trying to.
I believe that this term unambiguously says to a lay person, to a person in these people's shoes, the children must live in DC. I think residence is clear, home is clear, shall be, the home state and habitual residence is unambiguous. But if this court finds that it is ambiguous because maybe it's a reference to the UCCJEA, or maybe it's a reference to the Hague Convention on the Civil Aspects of International Child Abduction, even if it were those references, she still violated it. It still requires that the children live in DC. So I don't think it makes it ambiguous by finding that those are references to the UCCJEA or the Hague Convention, because it would still mean they have to reside in the District of Columbia. Council also pointed out that Miss Eddy had originally wanted to move farther away, realized she couldn't prevail with that, so she decided to do an incremental move, or to do the smaller move instead. And that's exactly the concern that I was raising about when people do draw hard lines in their parenting plans. They say, the hard line is the borders of the District of Columbia, and then we push that and we push that a little more and we push that a little more. Those incremental moves are what are so hard to address, and why I think specific performance is the remedy here, that the parties agreed this was their line. The kids live in
But
the
the
district.
specific performance, and this was brought up when we were talking to opposing counsel, the specific performance that you're looking for is to make Ms. Eddy move with the children. But if we agreed with you that this provision was an anti-relocation provision for the children, it doesn't say anything about where Ms. Eddy has to live.
Absolutely
Or the
true.
children have to live, but your client never asked for sole physical custody. Just asked for legal custody or joint legal custody with the power to override Ms. Eddy. So what do we make of that? I mean, again, it gets back to what's really going on here and what's the end game? Because it doesn't seem like your client actually wants the children to live with him full time
One remedy.
in the district.
One remedy, absolutely, Your Honor, is correct. One remedy is modifying physical custody so he gets 51%
He
of
didn't ask
overnight.
for that.
He
We're
a-
not going that way.
Right,
That has been forfeited,
he asked to
at
put,
least in this proceeding. You can go back to the trial judge and ask to change physical custody. We're not doing that here. So what is this about?
I'm endorsing Your Honor's point that that's a possible remedy he didn't ask for, right? He asked to enforce the provision that the children live
My
in.
point is,
the
I think you're
District of
missing my
Columbia.
point, is that the remedy that he asked for is a mismatch
I-
with the violation that he's alleging occurred.
The remedy he's asking for, modification of legal custody, matches the position that she is repeatedly intentionally violating the MSA. She believes that because she has sole legal custody, it doesn't apply to her. It doesn't bind her. She says that in her
I just
appellate
don't
briefs.
think that the record reflects that, and I don't think that that's an advantageous argument for you. So if we just focus on, there's an ambiguous provision that may be construed as a anti-relocation provision. Your client has just asked for joint legal custody with the ability to override her, and it all seems to be about where the kids go to school. It's not about where they live.
He asked for two things. Well, he filed two motions. He files a motion to enforce, and he files a motion to
I
modify.
understand he filed the motion to enforce, but the sole relief that he asked for in the motion to enforce was for joint legal custody with the ability to override her, seemingly with the aim of being able to say where the kids go to school.
In the motion to enforce, I believe, and I can pull it up if it's helpful, I believe that he asked more broadly for the court to enforce the provisions of the MSA set forth above. And what's set forth above is she moved in violation of this anti-relocation provision. But I think to the legal custody argument, it's that when he agreed in the parenting plan to sole legal custody, it was with safeguards. It was with this framework that the kids would be living in DC, that exchanges would be at her house, that, you know, all these different, that she would consult with him, that she would meaningfully consult with him before making these decisions. And so his position was, if these things go away, if she's not following the agreement anyway, she's just doing what she will do and tells me about it later, then sole legal custody is no longer in the children's best interest. Then we need to look at something with more specific requirements, or, you know, or joint legal custody, which is what he asked for. So I think that's the nexus, is the safeguards of the agreement have gone away. She acts first, tells me later. She moved out of the District of Columbia because she believes sole legal custody gives her sole decision-making over whether the agreement applies or not. Therefore, this sole legal custody needs to be modified.
Great, thank you.
Thank you, Your Honors.
All right, we appreciate council's arguments and briefs, and we'll take this matter under advisement. Our third and final case this morning is DEMANN SHELTON versus United States. Right, counsel, are you ready to proceed?
Good morning, and may it please the court. Ariba Jabril on behalf of DEMANN Shelton. I would like to reserve 2 minutes for rebuttal. The trial court erred when it responded to the jury's note by offering a supplemental instruction on joint constructive possession because it conveyed to the jury that it could convict on a theory that was unsupported by the evidence. This error was not harmless, as the jury had deliberated for 8 hours prior to the question being answered and said it was deadlocked. Less than 2 hours after the trial court's response, the jury convicted Mr. Shelton for possession of the firearm.
Sorry,
Go ahead.
go ahead.
You said that there was no evidence in the record to support the joint constructive possession charge, but a big part of the defense strategy at trial seemed to be probing the fact that the gun couldn't have been placed there by Mr. Shelton. He was on the driver's side, rear seat. The coat was on the passenger side, rear seat. The gun was deep down in the pockets. He couldn't have he didn't necessarily know it was there. It could have been put there by the furtive movements. So there was a lot of perhaps atmosphere, argument, theory underlying this that went forward at trial. Why was that not sufficient, given the fact that this arose from a jury question to contemplate that there was enough evidence at trial?
Defense had raised evidence that Mr. Smith's furtive movements suggested that he had been the one to place the guns and the drugs in Mr. Shelton's jacket. That was raised to create a reason to doubt, and the burden of proof there is only to show that there's a reasonable possibility that an inference is true. What the government is trying to do is use Mr. Smith's furtive gestures to suggest that he put the gun in the jacket, but then draw a further inference that he had to have been helped by Mr. Shelton in doing that. And to do that, they're required to show that that inference is true, to show that there's proof beyond a reasonable doubt.
Does he have to show that Mr. Shelton helped put the gun there? Or does he have to show that Mr. Shelton knew the gun was put there and that they were together a part of this enterprise?
So there's 2 separate theories that are being pursued by the government. On the first theory, it's that, Mr. Shelton and Mr. Smith worked together to hide the gun. On that theory, there does have to be proof that Mr. Shelton and Mr. Smith together had an intent to exercise dominion and control over the firearm. So just knowledge, if Mr. Shelton had just observed Mr. Smith putting the gun in the jacket, it would not be enough. Mr. Shelton, and so to address that to address that theory first, Mr. Shelton was not seen moving, and so there's no inference to be drawn that Mr. Shelton was moving around and he helped hide the gun. Second, we don't know the position of the jacket when the firearm was inserted inside of it. And so there's a lack of information in this record from which to draw an inference that Mr. Smith could not have reached the jacket himself and put the gun inside
But
himself.
how could the specific instruction or response, we can call it an instruction, probably more accurately called a response to the jury question, the one that the trial court gave here, not a generic joint constructive possession instruction, but the specific instruction given here, how could it have allowed the jury to convict Mr. Shelton of anything other than his own constructive possession of the gun?
Because what the judge did by instructing on this theory and was convey to the jury that this was an available theory on this record. The jury wasn't asking a theoretical question. They were asking a question because they were not sure how to apply the facts to the law. And so they wanted to know a little bit more information. If the judge had said, here's a joint constructive possession instruction, but you are not allowed to apply it on that case, the jury would have known. But because this instruction was given to them, there was an assumption that the jury could make, and probably likely did make here, that they could use that theory.
But what theory?
That joint constructive possession, that there was some indication that Mr. Shelton and Mr. Smith had worked together and together had the intent to use or
But is
exercise
that what-
control over.
Sorry, is that what joint constructive possession is? Why, what authority do you have for that?
Thomas.
Okay, I don't think Thomas says that.
Well,
I mean, what is joint constructive possession, if you just take those three words, simply mean, and the opening of the joint constructive possession instruction says this, that there's nothing inherently wrong with the notion that two separate people can constructively possess the same object at the same time, right?
yes.
And that's incontrovertible, I think, and uncontroversial, wouldn't you say?
Here, the jury had already been presented with a sole constructive possession theory. And so we're in sort of a narrow version of the law where sole constructive possession, that Mr. Shelton had possession of this gun, is out. We're in this theoretical landscape where only together, there could have been sufficient evidence for joint constructive possession if they together had possession.
No,
And that comes from,
go ahead.
that comes from Rivas. Rivas tells us that that they together had, that when it's joint, Rivas tells us that for constructive possession, you have to show that someone had the necessary intent to control the use of the firearm or its destiny. And when it's joint, they add that language with others. And that kind of conveys.
So if Mr. Shelton had constructive possession of the firearm and the evidence was sufficient to show that he had constructive possession of the firearm,
Yes.
is there anything that undermines that theory of liability as to him if Mr. Smith also had constructive possession of the firearm?
There would have to be something in the record to suggest that Mr. Smith also had it.
But that's not my question. My question is, if Mr. Smith also had constructive possession of the firearm, how does that bear on whether Mr. Shelton had constructive possession of the firearm?
I think it would just really depend on what theory has been put forward in front of the jury. And there was a theory that Mr. Shelton alone possessed it, that it was within his belongings and he had it by himself. And then there was a theory that they had worked together to put it in the jacket.
Okay, but let me give you a hypothetical. So let's say two people share a bedroom.
Yes.
And there's no question, they both use the bedroom, their clothes are in the bedroom, they are on the lease, and they're in the same place, and there's a gun on the nightstand. And it's Jones and Mr. Brown. I won't use Smith because we have Smith in this case. So the government's theory is that Brown constructively possessed the firearm. Does the government have to show, well, let me put it this way. To show that Jones and Brown both constructively possess the firearm, does the government have to show that they also engaged in some concerted action? Jones constructively possessed the firearm based on his residence in the room, proximity to the firearm, ability to exercise dominion and control over it. And Brown also did. Even though, let's say they both go to separate jobs, they're not common drug dealers, any of that, would the government have to show anything other than that?
I think that the government could proceed on two separate sole constructive possession theories. That, Jones separately had some tie to this gun and Brown separately had some tie to the gun, but that's closed off here.
But I don't understand why. So if the government is proceeding against Jones and the jury comes back with a question, and I know I'm paraphrasing the question that was asked here, so maybe that's your response, but the question says, is it a problem as to Jones if Brown also constructively possessed this firearm? Can't the court come back and answer that? No, it's not a problem. That's permissible.
I just think that's so far from what happened on the facts here, because here we know that the jury was deadlocked on that sole constructive possession theory. And here we know that the jury had been presented with this theory that Mr. Smith was shoving something into the jacket. And so
They were deadlocked?
yes, the jury had sent a note. When the jury asked their question, they had sent a note saying that they were deadlocked.
How do we know that the jury's confusion wasn't that wasn't whether they could convict Mr. Shelton of constructive possession of the firearm if they thought that Mr. Smith also constructively possessed the firearm. That's a reasonable reading of the jury's question? And if so, the court's response, which is that joint constructive possession is a thing in the law, and it simply means that two people constructively possess an item at the same time. But here, I want you to consider Mr. Shelton's liability without regard to whatever Mr. Smith did. And you have to find that Mr. Shelton exercised dominion and control over the item. And you can't do that based on his proximity to the item. So how is that not a perfectly acceptable instruction telling the jury that it has to find that Mr. Shelton constructively possessed the firearm?
I think that it just doesn't really address the confusion that the jury had, because the jury had already had a sole constructive possession theory put forward to them. And the judge's response specifically says, two or more persons have property in their joint constructive possession when they each have both the power and the intent at a given time to control the property.
Right,
And
exactly.
so there's a suggestion that at this given time, that Smith and Shelton together.
I don't think that's what it says. I think it says that Mr. Smith could constructively possess the firearm and Mr. Shelton could constructively possess the firearm at the same time. But I'm telling you that that for you to convict Mr. Shelton, you have to find, regardless of whatever Mr. Smith did, that he, Mr. Shelton, constructively possessed the firearm.
If that was the theory, then it would be that Smith, when he placed the gun into the jacket, somehow also transferred over constructive possession to Mr. Shelton. If the gun had always been with Mr. Smith and it was hidden somewhere on his body, we don't even know if that gun was visible. How could the jury have found that Mr. Shelton also had some stake in it or some?
Well, I think that your position is that the evidence was sufficient to find that Mr. Shelton constructively possessed the firearm.
But it's not sufficient if Mr. Smith was where that firearm originated.
That doesn't matter, because if Mr. Shelton constructively possessed the firearm at some point and the evidence was sufficient to support that, and the court told the jury that it had to decide whether Mr. Shelton constructively possessed the firearm without regard to whatever Mr. Smith did, then how is that not just a simple reiteration of a standard sole constructive possession instruction?
Because it's a joint, it's different because there's this implication that if Mr. Smith had the gun, they can convict Mr. Shelton. So it's giving them
It says it expressly tells the jury that it can't do that.
It says I further instruct you that if you consider joint constructive possession, in order for you to find the defendant possessed an item, notwithstanding the role of the front seat passenger, the government must still prove beyond a reasonable doubt all the elements of each offense, and that the defendant voluntarily and on purpose had the power and intent to control the item.
I think that part, the part that the defendant voluntarily and on purpose intended to exercise dominion and control, that part I agree is actually just a repetition of the sole constructive possession instruction that had already been given. So it doesn't alleviate the confusion. And where it says notwithstanding the role of the front seat passenger, I think that's confusing. I don't think that further clarifies.
But the instruction does say two or more persons can have possession in their joint constructive, can have property in their joint constructive possession when they each have both the power
Yes.
and intent to control. And I think I hear you saying that if Mr. Smith had the item, which is actual possession,
Yes.
not constructive possession, that there couldn't have been constructive possession on the part of Mr. Shelton.
If the gun had originated with Mr. Smith and then it was put into Mr. Shelton's jacket without his consent, then it can't be true. The facts can't show that they both each had the power to exercise dominion and control over that weapon.
But then the jury would have had to have acquitted Mr. Shelton of joint constructive possession under the instruction that was provided, because the jury, the only way you could say that then is to say that the jury didn't follow this instruction, which we presume that it did. And so if the jury the jury could not have convicted Mr. Shelton here under this instruction if it had thought that Mr. Smith put the gun in Mr. Shelton's jacket without Mr. Shelton's knowledge.
But that's all the facts have, right? The facts don't show, there's insufficient evidence that they were working together. But I think that
What do they have to have been working together? That was my initial question about,
they have to have been working together to be in response to the question that they both had both the power and the intent at a given time to control the property. So if the theory that the jury is considering is that Smith had the gun at first and then it was put into the jacket, then Mr. Shelton had nothing to do with that. He didn't have the power to exercise intent or control over the gun. He didn't
So
have
then
the show.
do Jones and Brown, from my earlier hypothetical,
Yes,
living in the same room
yes.
with the gun on the nightstand, and they each have dominion and control, or the intent to exercise dominion and control over that gun, you're saying that the government would also have to prove that they are in cahoots on a drug conspiracy or something like that?
Not necessarily, but there would have to be some tie to both of them. So I think Curry is instructive here. In Curry, Curry is sharing this apartment. She's crashing in it temporarily and there's two other people there who are in and out. They're operating a drug operation outside in the living room. She's crashing in the bedroom. Amongst her clothing in a nightstand, they find a firearm. And on top of that nightstand, they also find mail addressed to her. It's clearly, a nightstand she is using. When the police officers come there, they're not the ones who find, she's not present on the scene. And they don't convict her of constructive possession on any theory, sole or joint, because there's a concern that when there's multiple people in a space, that someone might be able to, someone might have stashed the gun there, even though there's no indication that someone other than her uses that bedroom. And so that's where, in Curry, they address, it's a concert of action that helps dispel this fear that when there are multiple people in a space, the constructive possession is going to fall.
Right. So it's evidence that might be required in certain cases to meet the sufficiency threshold, in certain cases to establish joint constructive possession. So if you vary my hypothetical and Jones and Brown live in separate rooms of this house and the gun is in Jones's room and the government wants to pin constructive possession on Brown, I'm mixing up the names now, but the government wants to say Brown constructively possessed the firearm. Well, then it might say, well, he was on the lease and sometimes he went into Jones's room. And then maybe that's not enough. So the government might have to say, and this court might reverse on a sufficiency question, because there was no evidence that, why would Brown be interested in Jones's firearm? Well, he was interested in it because they were engaged in drug activity together, right? That might be an additional piece of evidence that supports sufficiency as to whether Brown also constructively possessed the firearm. But I don't think our cases say that joint constructive possession as a doctrine requires that two people, it's not a vicarious liability theory, right? I mean, the government it's not like a Pinkerton theory of constructive possession. It's simply the notion that two people can constructively possess an item at the same time. But in some cases, to prove that one person who's not connected to the item jointly constructively possessed it, you might have to prove that they were in concert of action with the other person, but you don't necessarily always have to prove that, do you?
I mean, I think in Curry, it's clear that it's within her belongings and next to her stuff in a bedroom she alone uses. So I think the sole constructive possession theory is quite strong there. We're in a unique universe where both theories are not available. We're only looking at whether or not there was instructional error, and as part of that instructional error, whether or not there was sufficient evidence for just that joint constructive possession instruction. We've already conceded that there is evidence of sole constructive possession. So we're in this very weird, unique universe that is rarely addressed in the case law. It comes up in Thomas. And in Thomas, we have a situation just like this one, where there are two individuals, both who toss an object down. One of them, Mr. Thomas, actually tosses down a silver object. That's what the officers testify. And they later find a silver gun. But still, when the jury asks, can more than one person have had possession of that item? And the judge responds, yes, the court says, no, that's confusing. And it's confusing because it indicates to the jury that a joint constructive possession theory is available on these facts when it wasn't. And it wasn't because there was either evidence that Mr. Thomas had sole possession or either evidence that Mr. Parker, the other person, had sole possession. And that's sort of the similar situation.
But I don't think it is
here.
because in Thomas, only one of Mr. Parker or Mr. Thomas could have thrown the gun, right? And what the Thomas court, we were trying to preclude was the jury thinking that Thomas could be liable for Parker throwing the gun because Thomas and Parker were together.
That is what's happening here as well. If there's no evidence to suggest that Mr. Smith and Mr. Shelton were working together, whether that's on they hid the gun together theory or a drug possession theory or a drug conspiracy theory, because the jury can be confused here as well, that if Mr. Smith had alone been the one to hide the gun, that they can convict Mr. Shelton, and that's not an available theory.
Right.
There's a lack of evidence to suggest that Mr. Shelton had helped Mr. Smith.
Are you saying that what the trial court should have said was there's no theory of joint constructive possession available to you here?
Yes.
That should have been the instruction?
I think that could have been a possible instruction, yes.
But wouldn't that have told the jury incorrectly? Obviously, we don't know, and the trial court didn't know at the time either, why the jury was confused. And so one theory is that the jury was confused because it thought that it was wondering whether it can convict Mr. Shelton if Mr. Smith constructively possessed the gun. Another theory is that the jury was confused because it didn't know whether it could convict Mr. Shelton if it thought that he constructively possessed the gun and Mr. Smith constructively possessed the gun. And so faced with that question, the court determined that it should provide some answer to the jury. And if you look back at the transcript of the discussion of what answer to give, the court says, I want to answer their general legal question. That joint constructive possession is a thing. But I'm also aware of Thomas and the risk, and I'm paraphrasing, of course, here, so correct me if I get anything wrong on what the trial court said, but I'm wary of the risk that the jury will convict Mr. Shelton if it thinks that Mr. Smith did something. And so that's why, and then the court said, so I'm going to modify the language. And this is the instruction I'm going to give. And so it throws in this piece about notwithstanding the role of front seat passenger, and adds that you still have to find that Mr. Smith exercised dominion and control over the item.
So, I mean, what the trial court judge also says, if there was no basis in the record to support a finding of joint constructive possession, you're right, I couldn't allow them to find it, even if they were asking to. And the theory that's being considered that the judge rules on and allows this instruction on was that, Mr. Shelton had to necessarily have helped, that the jury can draw an inference to a subjective state of near certitude that Mr. Shelton and Mr. Smith helped and worked together. I think there's an additional point here that it's not necessarily true where this court is not required to find that the jury necessarily was confused on this specific basis. What Thomas tells us, it's enough if the jury may have convicted on this erroneous legal theory. So it doesn't require certainty on that front. Where certainty is required, where a subjective state of near certitude is required, is on the inferences that are allowed to be drawn here.
So then if we say that perhaps the trial court could have given a different instruction and we say that that was an abuse of discretion, then putting aside Griffin for a moment, but just going to harmlessness then, but I'm circling back all the way to a question I asked earlier, could the jury on this instruction have convicted Mr. Shelton of constructive possession if it did not find that he alone satisfied all elements of constructive possession?
That would be an erroneous, that would be, I'm sorry, I just want to make sure I understand your question. If the jury had found that Mr. Shelton had sole constructive possession, is that where you're asking?
No, I'm saying on the instruction that was actually given, is there any way that you can tell me that the jury could have convicted him of constructive possession without finding that he constructively possessed this firearm, regardless of what Mr. Smith did, if it had followed this instruction.
I mean, I think because they're being told that they can both possess it, and the manner in which the inference can be drawn on these facts is that the way that they both possessed it was by working together to hide the firearm. I think that putting the instructions to the actual facts and the actual record that the jury is deliberating on, I don't think that they could have found. I think that there's a big possibility here that what they found was that, Mr. Smith had hidden the gun, but it was in Mr. Shelton's jacket, and so they thought maybe it's one or the other. And I think there's indication in the record that this confusion is quite strong because they specifically say that they're deadlocked.
But if they had convicted on that basis, they would not have followed the instruction that they were given because they were told not to consider what Mr. Smith did. So
But they're also told to consider what Mr. Smith does in the initial part, right? When they're told two persons have property in their joint constructive possession, when they each have both the power and the intent. So
Right,
at that
being
point, so
told
there's a
that-
contradictory.
No, I don't think so, because they're being told that Mr. Shelton could have constructively possessed the gun at some point during this process, and Mr. Smith could have constructively possessed the gun at some point during this process. And those two things don't cancel each other out. They're not mutually exclusive. And
On
so,
this record, I think that they sort of are, because if Mr. Smith has the gun and maybe it's hidden somewhere on his body and Mr. Shelton has no awareness of it, then
they could have convicted, if Mr. Shelton had no awareness of it, then the jury could not have convicted him under this instruction because he would not have satisfied the elements that the jury was just told it had to find.
There's a suggestion here that the jury was confused because of this, right? There's a suggestion that because they were deadlocked when they had asked this question, and Thomas tells us it's not that we have to find that they were necessarily confused, it's that there may have been confusion. They may have relied on.
But they might have been confused because they thought that if Mr. Smith initially constructively possessed the gun, that Mr. Shelton could not also have constructively possessed the gun.
Yes.
And when they were disabused of that notion correctly, then the deadlock disappeared because they thought there's nothing wrong with the fact that Mr. Smith constructively possessed the gun and then handed it to Mr. Shelton. But we know we have to find that Mr. Shelton constructively possessed the gun regardless of what Mr. Smith did.
Maybe try to ask that question, because this is a similar question on my mind. Do you dispute that there was sufficient evidence here that Mr. Shelton solely possessed the gun?
No.
You don't dispute that?
No.
So if that's the case, then I have trouble seeing how the instruction on the joint possession changed that. I mean, because there is evidence here that the gun was found in proximity to Mr. Shelton in the backseat.
Mhm.
It's in his coat. His identification is in his coat where the gun is found. And there was also some other drug paraphernalia, I believe, found in the coat. So if that's sufficient for them to have found constructive possession for him solely, how does the joint constructive possession instruction, with all the language that we called out to you in it, refute that? In fact, it seems to double down on the fact that he could have constructively possessed it on his own. And then it adds this other piece.
If the court had wanted to say that joint constructive possession wasn't available, it could have said that. What it said was an indication that it was available. And so what the jury is thinking, joint constructive possession is a possible theory. And I can convict on this theory if I think that Mr. Shelton had something to do with the gun, even if I don't look at Mr. Smith's actions. But when we're only considering joint constructive possession, when we're putting aside all of the facts of sole constructive possession, what the judge's understanding is that the joint constructive possession basis is that Mr. Smith and Mr. Shelton were working together. But Mr. Shelton didn't move. He didn't make any movements to hide this firearm.
Yeah, I'm not following the leap to where Mr. Shelton and Mr. Smith have to be working together.
I think that Because the gun is in Mr. Shelton's jacket, for it to also have been imputable to Mr. Smith, he had to also have had some, had exercised some dominion or control over it as well. And so how could Mr. Smith have exercised dominion or control over this firearm if it had been in the jacket the entire time? And so on the joint constructive possession theory, it is both. It's that Mr. Smith had the ability to use or exercise dominion or control over the gun, and that Mr. Shelton also had the ability to exercise or use or dominion control over the gun. And if it had always been in the jacket, Mr. Smith would have maybe even no reason to know that it was there, and much less a reason, an ability to exercise control or dominion.
So just to clarify.
Yes.
Mr. Shelton is tried alone? right?
Yes.
So Mr. Smith is not on trial.
Mr. Smith is not on trial.
So the government has not charged Mr. Smith, at least as far as we are aware, in this case, with constructive possession of the gun
Yes.
found in your client's jacket.
Yes.
So they did not prove in this case that at any point that Mr. Smith had
Yes.
constructive possession of the gun in the jacket. That was just raised as a defense
Yeah.
theory to raise reasonable doubt.
Yes.
So they didn't prove that. And so if they didn't prove that he solely had constructive possession of the gun found in your client's jacket, then it would seem under the instruction that the court gave, there couldn't be joint constructive possession with Mr. Smith either, because Mr. Smith would have had to have the intent to exercise control. There's no evidence of
Yes.
that, right?
Yes.
So why are we talking about joint constructive possession in this case? I mean, why was an instruction appropriate on joint constructive possession?
We don't believe that it was. It wasn't appropriate because there's not sufficient evidence in this record of anything that both of them had to do with each other. But the judge gave this instruction, and I think the judge, by giving that instruction, suggested to the jury that this was an available theory.
But the court didn't give this instruction as an initial matter, right? I
Didn't.
mean, so the fact is that the jury got a question, the court got a question from the jury and has to decide whether and how to respond to that,
Mhm.
which we review for abuse of discretion, other than the legal content of the answer. And so the question then is whether the answer to the jury's question allowed them to convict the defendant on a basis that the evidence does not support. And so, again, we're not reviewing an initial decision whether to give a joint constructive possession theory in a case where joint constructive possession doesn't matter. But the jury is asking, is joint constructive possession a thing? And you agree it would be wrong for the court to have said, no, joint constructive possession is not a thing. So the court could have said,
It's not an available theory on this facts.
right. But then how is that meaningfully different from what the court ended up giving, which is first, joint constructive possession is a thing. But in this case, if you were to consider it, you have to consider Mr. Shelton's sole constructive possession. And so the fact that if Mr. Smith also constructively possessed the gun doesn't really matter, because you have to find Mr. Shelton's constructive possession regardless of what Mr. Smith did. And you have to find that Mr. Shelton exercised dominion and control and not base it on his proximity to the firearm.
So I think it because it introduces confusion. What the jury is thinking is first that the joint constructive possession is available, and this is how I apply it. And that when that theory just wasn't available, and I want to clarify that there's two levels of review here. First, this court has to decide whether there was sufficient evidence for joint constructive possession. Then decide whether or not the trial court had abused its discretion by giving that instruction. So the sufficiency question, which is reviewed de novo, I think there's a lack of evidence on this record to suggest that Mr. Smith and Mr. Shelton were working together.
Well, I don't know if that's the right standard of review. I mean, if we were reviewing an initial decision to give a joint constructive possession theory, that might be right. But we're reviewing the court's decision whether and how to respond to a jury question. And the first part of the response to the jury question is a general legal answer that a theory that the jury, a legal doctrine that the jury is asking about, yes, it is a thing. And then the court says, I'm paraphrasing again, but here, I want you to decide this defendant's liability for constructive possession without regard to what anyone else did. And so we're not really reviewing whether the evidence was sufficient to support a joint constructive possession theory as a general matter or in a vacuum. We're reviewing this court's particular response to this jury's particular question.
So in Thomas, this court did actually do the sufficiency review and then look at the jury instruction. So I think that this sufficiency review is required. But I also think that the language that you're pointing to, I don't think it clarifies the confusion, because what the jury is still being told is that joint constructive possession is a theory, and that Mr. Shelton and Mr. Smith both had the power and intent. So either the jury is told disregard one part or disregard the other. And I think your paraphrasing makes it sound more simplistic than more simple and maybe a little bit more easy to understand, or conveys maybe something different. Because what the judge actually says is, notwithstanding the role of the front seat passenger, and when reiterating that the defendant voluntarily and on purpose intended to exercise dominion and control over the item. But I think that there's a contradiction when you're looking at the entirety of the evidence of the instruction, right? Because the instruction says at one point, consider that they both had control, but then on a second point says only look at the defendant. And I don't think that, this entire instruction disabuses the jury of the confusion that they had.
Well,
And
I'm sorry, go ahead.
I just wanted to reiterate, we know that the jury was confused on that sole constructive possession theory because they had said that they were deadlocked.
Well, if we determine based on the facts and evidence here that there was sufficient evidence to convict Mr. Shelton on sole constructive possession, why would we need to remand on that, given our case law in Griffin and Inyema, I don't know if I'm pronouncing that correctly. And I know you rely heavily on Thomas, but Thomas, I don't think has ever been cited really since 2002, and seems to have been distinguished in Inyema.
So I think that if this court finds that there was insufficient evidence of the joint constructive possession, that the instruction was wrongly given, then first of all, Thomas is binding on this court. But Thomas specifically addresses Griffin when it says there's something different here than what happened in Griffin, because in Griffin, what the Supreme Court was considering only was a remote possibility, a remote chance that the jury had relied on a theory that was insufficiently supported by the evidence. Here, we don't have something that's like a remote theory. We have the jury saying that it was deadlocked. We have a jury asking a question, and we have the fact that after it was deadlocked after the jury was deadlocked after 8 hours of deliberation, but it returned a verdict within 2 hours after having gotten this response. And so we have much more in this record to indicate that the jury had relied on the theory that was insufficiently supported. And that isn't inconsistent with the language of Griffin itself, because in Griffin only applies in the absence to the contrary. That's the specific language used by the Griffin court. And other courts have done something similar. First of all, Thomas is binding on this court, so that is what applies. But if you wanted to look, if this court was interested in looking at what's happening outside of this court in the circuit.
Yeah, I didn't say it wasn't binding, but it seems like later cases may have distinguished it a little bit. But
so actually, Iniyama specifically says that, they refer to applying the Griffin presumption. So they actually are also considering it to be a Griffin presumption. What was different there was that there was no indication. There was a general verdict, so there was no indication that the jury may have convicted on the unsubstantiated theory. And that's also,
have a general verdict here too.
We have a general verdict, but we have evidence in the record to suggest that the jury may have relied on the unsubstantiated theory, which is the jury note, which is the jury conveying that it was deadlocked, and it's the timing of the deliberation. So the fact that the jury had deliberated for 8 hours, said that it was deadlocked, and then after getting a response to its question, responding within 2 hours.
So if we agree with you that the Griffin presumption doesn't apply, we still proceed to harmlessness. right? I mean, the Griffin presumption is one way. And if it doesn't apply, there's still the standard harmlessness inquiry.
I think those two inquiries collapse into each other. That once the presumption has been rebutted, it's the government's burden to show the error was not harmless. And that requires proof beyond a reasonable doubt that the error did not contribute to the verdict. So that's a very heightened standard that the government has to meet. And here, and the court can only find that it's not harmless.
But so then you're agreeing that if the Griffin presumption doesn't apply, then it's standard harmlessness review.
Yes.
Okay, but you're also saying it's Chapman harmlessness, which I'm not sure is right, because this would be an instructional error.
Right. I apologize, Your Honor. I think it would be that it was not substantially swayed by.
Okay, so even if we agreed with you that the Griffin presumption doesn't apply, we would apply normal government burden harmlessness, Kadiakis
Yes.
harmlessness. Okay.
Thank you, counsel. I know you reserved some time for a rebuttal and we'll provide that time to you.
May it please the court, Alan Darby for the United States. This court should affirm DeMann Shelton's firearm convictions because first, the trial court did not err in re-instructing the jury on joint constructive possession. Sufficient evidence.
Re-instructing. The court didn't re-instruct on joint constructive possession. It instructed them for the first time.
That's correct, Your Honor. And to put a finer point on it, constructive possession is one theory of possession, which can be either sole or joint. But I think Judge Schenker and
But
yourself noted
the
that.
government had solely pursued a sole constructive possession theory and had effectively disavowed a joint constructive possession theory. Mr. Smith had nothing to do with the government's case for constructive possession against Mr. Shelton, correct?
That's correct, Your Honor. But even taking that as a given, that's not the question before this court. The question is whether or not there is sufficient evidence to give the instruction on joint constructive possession.
It's a curious situation where the government hasn't pursued a joint constructive possession case for then the government to say, well, actually, we put on sufficient evidence for a joint constructive possession instruction that we didn't ask for in the first instance.
Right. I think it's curious, Your Honor, because the evidence were so overwhelming for sole constructive possession such that Shelton doesn't even challenge it on appeal. It's not until Shelton at trial introduces evidence of the actions of Mr. Smith, where this evidence is introduced to support reasonable inference of joint constructive possession.
Evidence of joint constructive possession. He introduces evidence. I mean, he is raising doubt about his client's sole constructive possession by trying to suggest that Smith had sole constructive possession.
So the reasonable inference that can be drawn to answer your question, Judge Easterly, is that Smith had possession of the firearm and placed it in Shelton's jacket. At most, that shows that both constructively possessed the firearm. There doesn't have to be some secondary concerted action to show they conspired to do.
There's zero evidence of like a 1-2 punch that you're suggesting now on appeal, right? There's no evidence. Like the defense tries to sort of raise doubts about, who actually had the gun in the first instance, and maybe Smith put the gun in the jacket. But there's just no evidence of, well, if Smith put the gun in the jacket, then what did Mr. Shelton do, right? Like that, there just seems to be two theories here. One, the gun was always in the jacket, right? It's Mr. Shelton's jacket. It's got his ID in it. It's got his mail in it. It's his jacket, right? And then there's this other theory that the defense raises at trial, which is Mr. Smith put the gun in the jacket. But there's no evidence suggesting that once Mr. Smith puts the gun in the jacket, then Mr. Shelton does something to show that he has an intent and a desire to exercise dominion and control. Like he doesn't pick up the jacket. He doesn't talk to Mr. Smith. Like nobody introduces any evidence of this. And it seems like that is kind of what's entirely missing that would need to be shown to either show some sort of sequential sole possession, which I think is what Judge Schenker was getting at, or some sort of joint possession in concert. They're both jointly constructively possessing it at the same time. There's no evidence of that.
Just to push back, Your Honor, I don't think that is correct. Just in terms of the layout of the car, you have Smith in the front side passenger seat, you have Shelton in the driver's side rear seat, the jacket sort of behind Smith. There's no question that Shelton had the knowledge and the ability to exercise dominion and control.
To argue in contradiction to Rivas that we can infer joint constructive possession based on their presence in the car. But we've said that doesn't fly.
So, no, Your Honor, that's not what I'm trying to do. So in Rivas, there was no evidence they were actively engaged in distributing drugs. And it cites to
What's the
Parker
evidence
and
in this case that they're actively engaged in distributing drugs together, right? Like there's no evidence that they possess the same kinds of drugs. There's no evidence that they talk to each other. There's no evidence that, Mr. Smith isn't just like a one-man show and has, that he needs Mr. Shelton for the money or the scale or that doesn't work or whatever it is, right? Like there's nothing there.
so I know there have been a lot of questions and I want to make sure I get to the heart of my answer to your previous one before I address this one. The jury would have had to have found that Shelton had the intent to possess that firearm based on the instruction on joint constructive possession. So that would be my answer to your previous question, just to put a pin in it. In terms of the evidence.
Can you just say that? I know I've got you talking fast because you're trying to answer all
Yeah.
my questions, but can you say what you just said again? The jury would have had to what?
The jury would have had to have found that Shelton had the intent to exercise dominion and control of the firearm based on the instruction on joint constructive possession. And so,
So I'm asking you the same thing I asked your friend on the other side then, which is why does it matter? You seem to be going down a path of what Mr. Smith did. And my question to both of you is the same question, which is why does it matter what Mr. Smith did under this instruction? I realize in a certain case like Thomas, where two people might have done something and you don't know which one it is, and the jury might think that I can impute liability to person B based on what person A did. I don't think that's a correct conceptualization of what joint constructive possession is, but let's say that's where the jury's confusion is. That an answer that joint constructive possession is a thing might be wrong. But here, the court told the jury that it couldn't think about what Mr. Smith did. And so I'm confused what's your conception of what joint constructive possession is? And why are you also focusing on what Mr. Smith did or didn't do?
Yes, Judge Schenker. So it's relevant in the sense that Shelton introduced evidence at trial that, and in fact, emphasized in its closing, at the very beginning of its closing, that Smith put this firearm in Shelton's jacket. And so, and this sort of goes to your question about, they're not really mutually exclusive theories. It can be sole and can be joint. There could be many reasons why the jury would have been deadlocked on the sole constructive theory. But in either instance, and this is what you were emphasizing earlier, the jury had to have found that Shelton constructively possessed this firearm.
So that's,
I
well, I was just going to say that to me, if I were standing where you are, which I'm not anymore, but I did, that would be the end of my answer. Like, so it seems like everyone is a little bit confused about what joint constructive possession is, and maybe we need to clear that up, but sorry, go ahead.
I just have a legal question. When somebody, say there's a gun where the chief is sitting and she's not there. She doesn't have anything to do with it. And so it's halfway between me and Judge Schenker, and I, sort of walk over and check on it for a second and then go sit back down. And then Judge Schenker gets up and goes over and checks on it and sits back down. I guess you could say, is that joint constructive possession? Is that, sequential sole constructive possession? Is sequential sole constructive possession the same thing as joint constructive possession? I would think that it's not, but I don't have a case to back me up. So,
So I mean, I think there is some line to be drawn where if there's sort of a discontinuing of action and you just, and it brings me into the line of cases about apartments, like more, perhaps if someone is not living in an apartment or they don't frequent it often, but they had a key, and there are so many different factual scenarios where that could change the outcome. And I don't think that's this case.
you don't think this is a sequential sole possession case?
I meant in the sense that it's not this case that there's just an open public area and there's a firearm and people just come by and check in on guns.
And Rivas says that doesn't get you very far. So, I mean, you know,
Well, just to answer your point about Rivas, I do think Rivas is not exactly on point because that was in a middle console and there were none of these sort of sounds or words or actions that connected them to this contraband here. It was found in Shelton's jacket. And then you have the furtive movements from Smith, and that was the entire theory from the evidence elicited about his panic nature, which was suspicious to officers, his furtive movements around himself, which officers thought he was hiding contraband and could be characteristic of an armed gunman. Then you had that no officer ever reported seeing Smith open or put anything into the glove box, which is where the other firearm was found, or put anything on his person, which was where the narcotics were found.
are you
And I-
making an argument that he had sole constructive possession over the gun in the jacket? I'm not sure where you're going with this.
Your Honor, I'm merely saying that's a reasonable inference that he had possession of the firearm and then placed it into Shelton's jacket.
Okay. And that's the defense's theory, is that he has sole constructive possession. How do you then get to sequential constructive possession, much less joint constructive possession? I just don't see, where is the evidence of that, right? And the question is can two people have joint possession of an item?
Yes.
And I don't understand why the government, and based on your discussion of the evidence, thinks that the court should have said anything about joint constructive possession, because it seems like you're talking about sole constructive possession either by Mr. Smith or by Mr. Shelton.
I think
possibly sequentially.
So I think sequentially is sort of far afield. I think as long as an individual has knowledge and the ability and the intent to exercise dominion and control, the timing really has no bearing on it. And so
Is joint possession, joint constructive possession different in your mind from two people both having sole constructive possession?
So this goes back to my initial point, is you have this broad umbrella of constructive possession, and it could be either an individual or multiple people having constructive possession of an item. But I did want to start with.
But can you answer the chief's question, just yes or no? Is joint constructive possession different from sole constructive possession, except for more than one people having sole constructive possession at the same time?
No, Judge Shanker. It's just the amount of people who have constructive possession of the item. That is my understanding.
I mean, if you look at the model jury instructions, the pattern jury instruction for joint constructive possession is verbatim the same as the pattern jury instruction for sole constructive possession.
Yes, Your Honor. Yeah, I would agree with that. I did want to circle back to Judge Easterly's question about the drug evidence before we move to another issue. And Your Honor mentioned about Antonio Smith. This is obviously not in the record on appeal, so it's not before this court in deciding this issue. But the defendants were severed, and he did plead guilty to possession with the intent to distribute cocaine. And he was found with 27 small baggies of a white rock-like substance on his person, which was, and I do want to make, and
I just don't understand, was any of this admitted at Mr. Shelton's trial? Like,
so the multiple small yellow bags of a white rock-like substance, which was consistent with the white rock-like substance that was found in Shelton's jacket. So I just wanted to tie those two together. There was evidence that there were consistent drugs found on both persons.
What do we make of the fact that the jury did not convict Mr. Shelton on the drug charge, but did convict him on the gun possession charge?
Yes, Your Honor. I think this is a sort of
suggests that they did follow the joint constructive.
So I think it's more of a suggestion or sort of a result of the problems we're having with DFS and actually getting lab testing for narcotics. And the fact that Shelton brought up at trial that we don't know what this narcotic was. The government can't prove that Shelton attempted to possess with the intent to distribute cocaine, because we do not know for certain that it is cocaine. So, but I think they can still consider the evidence in terms of a concert of illegal action of dealing drugs, because there was really no question that none of this was for personal use. In Shelton's jacket, you had 52 small zips of this white rock-like narcotic, 20 Suboxone strips, which the drug expert testified for 58 pages about the drug evidence. But these are routinely sold together. You had 2 firearms in this locked vehicle that was illegally parked virtually in a back lot. So these people didn't wander onto this vehicle. And then you had the scale and all of that.
But sort of getting back to the constructive possession issue with respect to the firearm and Mr. Shelton, are you, there were a number of items found in Mr. Shelton's jacket. Sort of one-stop shopping, perhaps you could argue, some of the drug paraphernalia, the identification and the gun. But for our purposes now, we're focused on we're focusing on the gun and what impact, if any, the joint constructive possession instruction in response to a jury question had on the jury ultimately convicting Mr. Shelton of constructive possession of the gun.
So if could your honor repeat exactly like the
You're
question?
saying, I hear, or I understand your argument to be that the joint constructive possession instruction didn't matter. Because, and I'm trying to figure out the because. Why didn't it matter here with respect to his conviction?
So it did not matter. And I guess beginning with the jury note, the jury did say it was deadlocked. Can more than one person have constructive possession or possession of an item? That, despite what Shelton contends, that's not evidence that they discredited the government's theory. I think it's more so a credit to them believing that, yes, Shelton had constructive possession of this item, and we also credit defense's testimony, maybe Smith did as well. And so the government, the judge, after about 5 to 10 pages.
Proof, I mean, there's nothing approaching proof beyond a reasonable doubt of joint constructive possession. I think you answered Judge Schenker and said, look, if you look at the model instructions, the joint constructive possession is the same as the sole constructive possession instruction. And that might be true. I haven't gone back and looked at the model instruction, but our cases do talk about, like, if you're going to have joint constructive possession, you need to show some evidence that people are acting in concert with each other, right? And that just makes sense, right? And not to put the chief in the hot seat, but if she has a gun, right, and you want to show that she actually possesses it, you want to show that Judge Schenker and I constructively possess it, you're going to have to show, I mean, the showing of the intent and knowledge to control the item is going to have to be shown through something of, we're at her side and kind of blocking people from getting to her weapon, or we're in some sort of enterprise with her, such that we need her with the gun to act, and that wouldn't be oral argument. She doesn't need to be armed for that. So, but, the whole in concert piece seems to be important, and the government just didn't put on any evidence of that.
Well, respectfully, I would disagree. That is all the 58 pages of the transcript for the drug evidence, that the gun was a part of a larger conspiracy to street distribute narcotics. And also
Those were Mr. Shelton's narcotics.
And Mr. Smith's. The narcotics that were.
So the evidence of Mr. Smith's narcotics came in, I haven't gone back to check this, came in at Mr. Shelton's trial under what?
Yes, Your Honor. So the sequence of events was, after he fled the vehicle and pushed an officer, fled headlong for over 100 meters, they eventually apprehended him and recovered small yellow zips containing a white rock-like narcotic that was consistent in appearance to the white rock-like narcotic in Shelton's jacket.
Right.
But the trial court didn't rely on any of this. I mean, the trial court explicitly sort of rejected the notion that there was concert of action related to drugs here.
I don't think so, Your Honor. The specific point the trial court was dealing with was Thomas and crafting an instruction or a response to the jury note that was in line with Thomas. And the court distinguished the facts here from Thomas, that it was not the case that either of them possessed a firearm and that there was no evidence that either could be true.
And you seem to be accepting the premise that there has to be concert of action in all joint constructive possession cases.
No, Your Honor, I don't think that's the case, and I would turn this court to Moore because I think that is very emblematic of sort of this issue. There, this court said where knowledge and an ability to exert control over contraband is established, the additional evidence needed to prove constructive possession is minimal. And a concert of illegal actions such as drug dealing could make a prima facie case of that. So I don't think to the leap, if it's.
That agrees that there has to be evidence of a concerted action. You're just quibbling about how much evidence.
No, Your Honor, because the evidence in that particular case was about drug distribution. So they're saying in this particular instance, this could create a prima facie case. But the evidence needed to get to the intent aspect, which is routinely proven by circumstantial evidence, is minimal.
But so do you think in my Jones and Brown hypothetical, sharing the same room, or the hypothetical that Judge Easterly offered with the gun right here between us and both of us periodically checking on it, that someone would have to show that Judge Easterly and I were engaged in some concerted action in addition to the evidence of us checking on the gun and both being, or Jones and Brown engaged in some concerted action? Do you agree that?
So, and can you remind me what the setting is of Jones and, do they both own the
They're both,
apartment?
they lived in the same room.
Okay.
Single room,
Mhm.
gun on the nightstand,
Okay.
both associated with the room.
So I think it would depend on when they recovered the gun. These are facts that would sort of go into the analysis. When they recover the gun, who was there? What potentially, if they both lived there, what side of the nightstand was it on? Were there other effects that were placed beside the gun?
Well,
And
sure,
that would
you
be a
might have
much
to show
tougher
that,
case.
you might have to show that to establish constructive possession as to either of the defendants. Right.
Mhm.
But do you also have to show that they engaged in some concerted action?
So the fact, I think, at base, the fact that they both had, presumably because they both lived there, have knowledge of the firearm, it's in their room, they have the ability to exercise dominion and control over it. And from circumstantial evidence, like I was alluding to, you could establish intent. I don't think you need to say, oh, we found drugs in a CVS bag in the closet with both of their names in it. They were engaging in street distribution. This is what proves up our theory.
Can I take you back to my question a moment ago, which I'm not sure you finished answering, which is what impact, I mean, the issue we're presented with is whether the judge's response to the jury question, giving the joint constructive possession instruction was error and if it was harmful. And I'm not sure I've heard I'm not sure I've heard you finish your answer to that question.
Apologies, Chief Judge Blackburn-Rigsby. I think this sort of gets to the second issue and how this case is distinguished from Thomas. There, despite Shelton's contention, that this court did not reverse the trial court because it thought the jury note somehow rebutted the Griffin presumption. What it found is that the trial court committed legal error by permitting the jury to think that it could convict on an unsupported theory of joint constructive possession. And here, that is not the case. Thomas is readily distinguished here.
Is there legal error here on the part of the trial judge responding to the jury note? And if there was it harmless? Or harmful?
No, Your Honor, and Shelton has never contended that the judge's response to the jury note was legally erroneous or erroneous in any way. They try to cast doubt that perhaps the jury might have misconstrued it. It could have been ambiguous, but juries are presumed, I think as Judge Schenker noted earlier, juries are presumed to understand and to know what the jury instructions set out and to follow them. And they have pointed to nothing in the record to sort of overcome that presumption. At most,
Confused by your answer. I thought their whole argument was this instruction never should have been given. So I don't understand how you can say they're not arguing that it was wrong. That's why we're here. Can I ask you about Griffin? You know, you're trying to distinguish it because the court says something about legal error, but looking at, or sorry, Thomas is talking about Griffin seems to say this presumption is rebutted. It says this case differs from Griffin because the jury's note to the trial court suggested that it was considering a verdict based on joint constructive possession. And the court's response did not disabuse them of the availability of that theory on the facts of this case.
And the above
Seems like exactly what Mr. Shelton's
the
arguing.
above paragraph, Your Honor, respectfully, I would disagree.
I know what I know what you're referring
Yeah,
to,
the legal abuse.
but at the end of the day,
The,
right, that's where the court lands, is saying, you know, the court has some possibly ill-advised language about what is or isn't legal error. Okay,
Mhm.
but at the end of the day, it's saying this is the problem and this is why Griffin is distinguishable. This is why the presumption is overridden. Because the jury's note to the trial court suggested it was considering a verdict based on joint constructive possession, and the court's response did not disabuse them.
the court's response did not disabuse them of that theory. And the paragraph above, when it's discussing Griffin, specifically states, well, Thomas's argument on appeal is that the court erred in instructing the jury. And we agree that was legal error to instruct the jury. That's the basis for the
Instruct the
Thomas case.
jury versus answer a jury note? Is that the distinction?
Well, I'm
I
using
think we're talking about two separate things here, I think, if I may. We're talking about whether an erroneous jury instruction that allows the jury to convict where there's insufficient evidence to support that jury instruction is a legal error or a non-legal error subject to the Griffin presumption. And I think, although they can correct me, Mr. Shelton can correct me, that Mr. Shelton agrees that Griffin got that wrong and that that's not a legal error. In other words, the type of error where the jury instruction tells the jury that an element of the offense is not required to be proven. That's different. That's question one. So whether the Griffin presumption applies here or not as whether the error here was legal or sort of factual. And I think in Griffin itself, it shows that this type of error is a sort of factual error that is then put through the Griffin presumption test. The second question here is whether the court's answer here was sufficient to overcome the Griffin presumption, or whether the facts here triggered the Griffin presumption and whether the court's answer disabused the jury of the incorrect, what Mr. Shelton says is an incorrect presumption about joint constructive possession. And I think those are two separate questions. And so now I've forgotten what my question is. But
well, I think your honor's right. There is and I don't want to get too far into the weeds with Griffin because I don't think the court has to address this issue. I think Thomas is readily distinguishable here, just on the basis of the instruction. There was no legal error in setting out the red book about what joint constructive possession is, and including notwithstanding what you think Smith did in front passenger seat, you have to find.
I just don't think that's where we are, though. I think what the argument is they're based on the facts. The court shouldn't have given this response. And we're only going to talk about Griffin if we think that argument is correct, right? So assume, just for the sake of argument, that we think that there was not sufficient evidence for the court to give the response that it did about joint constructive possession.
Okay.
Then why don't we have to reverse under Thomas?
Because Thomas is distinguished on.
Based on the language that I just read to you 5 minutes ago.
If
said, we see this jury note and they were confused and this just.
Respectfully, Your Honor, I read Thomas differently, just saying the legal error, which is what it said in its analysis of Griffin, was the response to the jury note, not the fact that they submitted a note. Shelton has pointed to no case where a jury note has been found to overcome Griffin. But turning back to Judge Schenker's point of sort of, if you're in the Griffin landscape, what are you sort of doing, or like, where are we at? So on a Yates Supreme Court Kate Yates analysis per Griffin, you must overturn the verdict if a theory was based on a mistake of law, which Shelton hasn't alleged here. If you cannot determine under what theory the jury convicted. However, if you're purely claiming that a theory was insufficient to be given, that's a Turner analysis per Griffin. And it's the government's contention that you would uphold the verdict as long as there is a sufficient theory to support it, or at the very least, per Shelton's interpretation, you would have to sort of see if there was some evidence in the record that overcame that rebuttable presumption. Thomas didn't do that. And I would sort of also like to point out that I mean, I've lost my train of thought there.
Was there a doubt here about which theory the jury found that they based their conviction on the gun charge for Mr. Shelton?
So Your Honor actually reminded me of my point. I don't, yeah, thank you. I don't think there is a doubt because of the clear language from the response to the jury note. And you really see this in this circling back to an earlier point, and I think Judge Schenker's point. In this line of Griffin cases, you commonly see multi-object conspiracies where potentially you have different acts that may or may not be mutually exclusive, versus here two inclusory theories. It's not the case that if, as Shelton sort of contends on appeal, that if the jury thought that yes, Shelton and Smith jointly constructively possessed the firearm, that he did not constructively possess the firearm. At base, under both theories, he had to constructively possess the firearm, and that is not in dispute.
So is that also a question that if we were to agree with Mr. Shelton that the Griffin presumption doesn't apply in the government's favor, that we proceed to a harmlessness inquiry?
Yes, Your Honor, I think under Kadiakos, as you referenced earlier.
And so the harmlessness inquiry then would be what? It would be whether the jury could have convicted Mr. Shelton for something he didn't do here? Or, well, I guess would it be whether not giving the instruction would have changed, not giving the answer to the jury note would have changed the outcome of the trial?
Yes, and I suppose that would also be dependent on what the judge actually did in response to not giving the jury note. If the judge just didn't say anything and just said that, you have the final instructions, this is all you need to know, exactly what would happen. I don't think it's substantially swayed the outcome, because I think it's just as reasonable that they believe that Shelton and Smith possessed the firearm as opposed to.
The government has to show that prove that it didn't substantially sway the outcome. And I think what Mr. Shelton's argument is, I was, proceeding quite nicely where I had a jury saying I can't reach a verdict on this count where the government has only pursued sole constructive possession, and then the court changes the rules of the game and says something about joint constructive possession, and lo and behold, I get convicted. I mean, that seems pretty strong to me. It seems hard to argue that there isn't a reasonable probability that instruction changed something.
I don't think it's changing the rules of the game, Your Honor. I mean, the exact language notwithstanding the role of the front seat passenger, you have to find that the government proved beyond a reasonable doubt each element to each offense.
My focus is on the first part of the instruction where the court is saying, sure, joint constructive possession is a thing. You can consider that here.
With the caveat of I think there are 3 paragraphs that was carefully crafted with Thomas in mind, and there was language included and excluded at both parties' behest in crafting this response. But if there are no further questions from the panel, we would respectfully ask this court to affirm. Thank you.
Great, thank you. Mr. Brill?
Thank you. I just have a few points on rebuttal. First, the instruction would be erroneous if the jury was allowed to convict of joint constructive possession, either because Mr. Shelton and Mr. Smith were seen to have worked together, or because Mr. Shelton and Mr. Smith each had separate but simultaneous constructive possession at the same time, because there's insufficient evidence of either. And so there's not sufficient evidence to show that if Mr. Smith had the gun originally, that Mr. Shelton also had some ability to exercise, show, or control, control the use or the destiny of that gun if all that happened was that Smith stuffed it into his jacket. And there's not sufficient evidence to show that if the gun was in Mr. Shelton's jacket the entire time, that Mr. Smith had the ability to exercise dominion or control over it when it's not his jacket.
Right, but that hurts Mr. Smith. And he's not on trial here.
It also hurts Mr. Shelton, right? Because
Not if the jury had to find that at some point, any point during this incident, he had constructive possession of the firearm.
but what the jury's note indicates, and why this instruction was error, was because there's a suggestion that there's joint constructive possession available. And so, yes, what Mr. Shelton could have been convicted the entire time on a sole constructive possession theory, but the jury was deadlocked. It had deliberated for 8 hours on that theory. And so after this instruction, there's some suggestion that they're considering, the language of the instruction that's been given to them. And that language is telling them that either, Shelton and Smith worked together and that's insufficient, or that Shelton and Smith each had separate but simultaneously constructive possession, and that's also insufficient. And we don't have to show that it necessarily relied on one of these three things. What we have to show that comes from Thomas, that it may have relied, that the instruction was erroneous and the jury may have relied on one of these theories. And the fact that the jury returns this verdict 2 hours after, when it had been deadlocked, when it had deliberated for 8 hours, suggests that it may have relied on an erroneous, interpretation or application of a joint constructive possession theory onto these facts.
What's the wrongful theory that you think that the jury possibly convicted him of? Was it what? That Smith put the gun in his jacket and he knew it?
And that Mr. Shelton, didn't have that Mr. Smith put the gun in Mr. Shelton's jacket, but he didn't help him. He didn't have the ability to exercise dominion or control. He didn't want the gun in his jacket. It's just that, while the police are running up in this interaction of a couple of seconds, less than a minute, Mr. Smith doesn't have the ability to, Mr. Shelton couldn't do anything. The gun was placed
That would not be sufficient to convict Mr. Shelton.
Yes.
If he didn't know.
Yes.
The
Yeah.
judge told the jury that it couldn't do that. It said it had to find that he exercised dominion and control over the item. So the jury could not have convicted him on the basis of on the idea that Mr. Smith put the gun in the jacket and Mr. Shelton didn't know about it. It's impossible to reconcile with this jury instruction.
I think that when we're only looking at joint constructive possession, there's really two options: that they work together, or that they had separate simultaneous sole constructive possession. But how could they have had separate simultaneous sole constructive possession if the gun was always in Mr. Shelton's jacket and Mr. Smith never touched it, never did anything with it, or that the gun was always with Mr. Smith and then it was stuffed into Mr. Shelton's jacket without his consent?
But there could be myriad possibilities of what happened here that the jury is entitled to consider based on the admitted evidence, as long as it was required and did find that Mr. Shelton exercised dominion and control over this firearm at some point relevant to the incident.
Those myriad of possibilities have to go beyond proof of a reasonable doubt.
No, but it doesn't matter Mr. Shelton might have put it in right before the police came. He might have put it in 2 hours before the police came. He might have put it in with Mr. Smith. He might have put it in without Mr. Smith.
That's
Mr.
not
Smith.
conjecture.
Oh, right. I agree with you, but I'm saying it doesn't,
Oh.
I'm saying it doesn't matter, because if the jury had to find under any of those possibilities that he exercised dominion and control over it, then it had to find that he constructively possessed the firearm. And the trial court told the jury that it had to find that he, Mr. Shelton, exercise dominion and control over the firearm.
I think that's ignoring the possibility that the jury got confused and made a mistake based on this instruction. The jury was deadlocked on a sole constructive possession theory. If that's what it wanted to convict on, it had that path and it had deliberated for 8 hours and didn't
But
convict
we,
on
I
that.
mean, we don't engage, and nor does the trial court, in figuring out why the jury is confused. And I posited, I think, a reasonable or plausible reason, plausible basis for the jury's confusion, which is that it didn't know if it could convict Mr. Shelton if Mr. Smith also constructively possessed the firearm. I mean, that's at least a plausible reason for confusion, right? And so when it asks, can two people possess something at the same time? And the court says yes, but you still have to find that Mr. Shelton constructively possessed the firearm. Then the jury goes back. I'm theorizing, I admit that, but I'm saying it's plausible.
Plausibility doesn't get you.
No, but I'm saying
subjective.
you're suggesting that this is why the jury is confused. And I'm just saying that we don't know that that's why the jury is confused, because there's an equally plausible reason to the contrary, which is that once the jury went back and said, oh, it doesn't matter if Mr. Smith also constructively possesses firearm, that doesn't preclude Mr. Shelton from constructively possessing the firearm. Now we can convict that that's a possibility too.
We don't have to know for certain whether the jury did convict on the unsupported theory. We just have to, it's just enough that the jury could have. And the jury could have on the basis of this instruction. If the jury, it had been clarified to the jury, sole constructive possession is the theory, joint
But
constructive.
I'm saying you're positing a theory as to why the jury was confused and asked this question.
Yes.
And that should have dictated what the answer the judge gave. But I'm saying the judge might have also thought that the jury was confused in this opposite way. And so.
But the judge says why it's confused. The judge says, I think they're confused. They have a whole back and forth. There's a whole argument between trial counsel and the judge about whether or not there's sufficient evidence to convict on a joint constructive possession theory. And they're talking about whether or not Mr. Smith and Mr. Shelton could have jointly possessed the gun, whether it was reasonable to infer that Mr. Shelton had helped Mr. Smith put the gun. So that's actually what's happening. And regardless, there could still be error here if the jury had convicted on the supported theory. So long as the jury instruction created confusion, so long as the jury instruction conveyed to the jury that it could convict on a series of possibilities that are unsupported by the evidence, that's enough.
I just thought that initially your argument was we have to look at what the evidence is to see whether it's sufficient
Yes.
for a response.
Yes.
Right? That has to be the first
Yeah.
step. So whether the court thinks that they're asking, can they jointly constructively possess the gun, like at the same time, or whether the court thinks they're asking, can one of them constructively possess the gun and then another one constructively possess the gun. Either way, the evidence doesn't support constructive possession for Mr. Smith and Mr. Shelton.
Yes. Yes. So that's exactly correct. First, there has to be sufficient evidence for the joint constructive possession theory. And then
so when we're talking about what the instruction actually then told the jury, that then we're getting sort of into harm territory, because the court never should have said anything about joint constructive possession to this jury.
yes. Yes. And I just, to add, the language about notwithstanding the role of the Smith, it's sort of repetitive of the instruction that was given at the outset, because the jury has been instructed in the beginning on sole constructive possession. And they're asking this question. The fact that they're asking this question indicates that they didn't think he had sole. That's why they're asking. And then we believe that Thomas and Griffin are consistent with each other. And Thomas specifically addresses Griffin and says that there's evidence to the contrary here, which was not in Griffin, and says that, to repeat, ignoring the likelihood of the jury convicting Mr. Thomas on a theory unsupported by the evidence is the error that it's considering. So it's clearly considering a sufficiency error, and it's clearly looking at whether or not the presumption has been rebutted, whether there's evidence to suggest that the jury had convicted on an unsupported theory. And so I think if that's all, I'd like to ask.
All right, we'd like to thank counsel for your arguments and your briefs today, and we'll take the matter under advisement. And that concludes our matters.